Ordre. The Public Order Emergency Commission is now in session. La commission sur l'état d'urgence est maintenant ouverte.
Okay, bonjour, good morning. Bienvenue and welcome to this new phase of the public hearings. Over the last 6 weeks, I've heard from over 75 witnesses who testified about the circumstances that have led to the declaration of a public order emergency and the use of powers under the Emergencies Act. These witnesses have provided me with many perspectives on those events, including the views of public servants, police forces, protesters, residents, and political officials. That evidence has been critical in allowing me to discharge the fact-finding portion of my mandate. Nous entamons aujourd'hui la deuxième phase des audiences publiques. Celle-ci concerne un volet différent de mon mandat. Lorsque j'ai été nommé commissaire, on ne m'a pas seulement demandé de faire de la lumière sur ce qui s'est déroulé en janvier et en février 2022. On m'a aussi confié la tâche de formuler des recommandations pour l'avenir. Ces recommandations doivent aborder une éventuelle modernisation de la loi sur les mesures d'urgence ainsi que d'autres enjeux qui méritent d'être étudiés. On m'a également demandé de tirer des conclusions concernant plusieurs domaines spécialisés, des plateformes de sociofinancement à la mésinformation sur les réseaux sociaux. For the next 5 days, the Commission will hear from a series of experts and expert roundtables, each one devoted to a different topic that is relevant to the Commission's policy mandate. These discussions will assist me in making the recommendations that will be contained in my final report. The organization of these roundtables was undertaken by the Commission's Research Council, which has provided the Commission with excellent support throughout the process, including the commissioning of papers. And in that regard, I just wish to note that some of the papers contain factual statements or factual assumptions that may not have been borne out in the evidence led at the hearings. Of necessity, of course, these papers were prepared in advance of the fact hearings, and those factual assumptions or statements will not be considered as evidence and will not be considered in reaching my conclusions. Obviously, I will reach conclusions based on the facts I have heard in the course of the hearings and in the documents contained that were filed. Now, parties withstanding at the inquiry were consulted and provided valuable input on the topics to be addressed, the process that the roundtables should follow, and who should be invited to participate. As a result of that process, the Research Council prepared 9 roundtables involving approximately 50 expert participants. The experts include both academics and practitioners in such areas as such areas of the law as policing, intelligence, and government. For those who have been following our proceedings so far, the policy phase will look somewhat different, both physically and in how it's going to proceed. Rather than examinations by lawyers, the roundtables will start with a facilitated discussion led by a moderator. During this discussion, parties withstanding at the policy phase will be submitting additional questions to Commission Counsel, who will then conduct their own questioning of the participants based on the input received. I, too, may have questions to ask the participants. Le Conseil de recherche, les modérateurs et les participants ont consacré de longues heures à la préparation des tables rondes qui se tiendront cette semaine. Je tiens à les remercier, tous et toutes, d'avoir fait preuve de générosité en acceptant d'appuyer la Commission dans ses travaux. Sur ceci, je cède la parole au doyen Robert Lackey, qui animera notre première séance sur les droits et libertés fondamentaux qui entrent en jeu lors de manifestations et leurs limites. Doyen Lackey, la parole est à vous.
Merci beaucoup, Monsieur le Commissaire. Donc, je suis Robert Lackey, le doyen de la faculté de droit de l'Université McGill. J'ai le plaisir de vous présenter les panélistes ce matin. Brian Bird, Assistant Professor, Peter A. Allard School of Law, University of British Columbia. Jamie Cameron, Professor Emerita, Osgood Hall Law School, York University. Jean-François Gaudreau-Desbiens, Professeur, Faculté de droit et vice-recteur de la planification stratégique et de communication de l'Université de Montréal. Vanessa McDonnell, Associate Professor in the Common Law section of the Faculty of Law, University of Ottawa, also co-director of the U-Ottawa Public Law Center. Carissima Mathen, full professor in the Common Law section of the Faculty of Law, University of Ottawa, and Richard Moon, full professor, Faculty of Law, University of Windsor. This roundtable aims to lay out the foundation and framework for the fundamental freedoms under the Canadian Charter of Rights and Freedoms. Rights to freedom of expression, assembly, and perhaps association. Protesters regularly exercise these democratic rights, and governments seek to justify limits on those rights. I think there will be consensus on the importance of these rights of democratic participation and the need for sound justifications for limiting them. Beyond that, Commissioner, it's possible that one takeaway will be that reasonable people disagree on the complex challenges of fleshing out and concretizing these rights in our free and democratic society. We have a lot to address this morning, and I remind participants of the need to keep their answers concise. We're going to kick off with a brief primer on the Canadian Charter of Rights and Freedoms, perhaps set against the history of rights protection in this country. Rights have not only been protected through entrenched bills of rights. And so we'll have a little introduction to that, including the notion of substantive rights, limitations on them. And we begin with Professor McDonnell.
Thank you, Dean Leckie. So in terms of setting the stage for today's discussion, it actually does make sense to go back a little bit further than 1982, when the Charter was enacted, and to just touch briefly on Canada's history of rights protection, because we do have a longer history of rights protection in this country. The common law has long protected rights in Canada, and Canada also has a history of statutory protection of rights, most notably at the federal level through the Canadian Bill of Rights, which is an ordinary statute which in the 1960s codified a set of rights and freedoms. Now, this pre-1982 history is certainly not an unblemished one. It's part of a broader history that includes notable failures in rights protection, and so that needs to be acknowledged as well in discussing Canada's pre-1982 history. So that brings us to 1982 and to the Charter, which formed part of a package of constitutional reforms that included the recognition of Aboriginal and treaty rights and a domestic amending formula. So the Charter creates a catalog of judicially enforceable rights and freedoms. Some of these rights and freedoms are a part of many constitutions around the world. So you'll hear us speak today about the right to to freedom of expression, to the right to equality, the right to vote, possibly. These are all core guarantees that are found in most bills of rights. There are other aspects of the Charter that are unique to Canada, and that would include, for example, the language rights provisions of the Charter. As Dean Leckie mentioned, the Charter is constitutionally entrenched. That means it's supreme law, and that laws that are enacted that are inconsistent with the Charter are of no force or effect. The Charter also prohibits state actors from violating rights, and so that means that state actors must conduct themselves in ways that are compliant with the Charter. And so that brings us to another important foundational point, which is that the Charter binds state actors. And what that means is that the state is bound to respect constitutional rights, but there aren't rights that are held as between private parties. Some of the rights and freedoms that you'll hear us talk about today include the fundamental freedoms, so freedom of expression, freedom of association, freedom of peaceful assembly. These are the core rights that are engaged in the context of a public protest. But there are also rights here that may not be immediately obvious, but which form an important part of the discussion. And so those include Section 7, which is the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice, and Section 15, which is the right to equality. To the extent that arrests or detentions were made in connection with the protests, the rights of accused persons, found in Sections 7 through 14 of the Charter, are also relevant. So what do these rights mean? How have they been interpreted? Well, the meaning of the Charter and of individual Charter rights has developed over the last 40 years, largely through adjudication in the courts, but also through the involvement and interpretations of political actors. And I think it's fair to say that in complex situations like the ones that gave rise to the convoy, there are complex rights issues. And so in discussing how Charter rights were implicated as part of the convoy, it's important to surface all relevant rights. The rights that were potentially violated as a result of the state response, but also the rights that were protected by the state response. Because I think it's clear that the state, in response to public events like the ones that we experienced, have an obligation to respond in some way. And so I'm going to turn things over to my colleague, Professor Mathen, here in a moment, but perhaps I can sort of set things up a little bit by saying that Charter issues, when they're adjudicated, are adjudicated really in two stages. And so at the first stage, the question is, are rights engaged? Have rights been limited? And if there's no rights violation, that's more or less the end of the story. If a right has been violated, the second step in a Charter analysis is whether any limits on rights have been justified. And so I've really been speaking about that first stage of the analysis, and I'll turn things over to Professor Mathen to speak about the second stage.
Thank you, Professor McDonnell. Professor Mathen.
Thank you very much. Section 1 of the Charter states, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Its purpose is to guarantee all the rights and freedoms in the Charter and to state that those rights are subject to reasonable limits. Now, the fact that rights would be subject to any limits might seem counterintuitive, but in fact, in most constitutions, there are very few absolute rights. A concern that might be raised about Section 1 in particular is that it appears to undermine the way that we understand something as a right because of its reference to democracy, which might suggest that rights can be reasonably limited if a large enough majority in society wants them to be. Sometimes we refer to this as the tyranny of the majority, the idea that in a democracy, minorities can be vulnerable if they lack political power or are very unpopular. Section 1 does not operate that way. For something to be a reasonable limit, it is not enough that a majority, even a supermajority, really wants that limit. This is because the reference to democracy is not to majority wishes alone, but to a broader conception. What does it mean to be a free and democratic society? Section 1 exists not as an exception to rights based on the wishes of a majority, but as a confirmation that rights are essential in a democracy. Like everything in the Charter, Section 1 is a legal tool. So it has a recognizable and routine framework in place for almost 40 years, whenever it arises in a legal case. The framework both draws on the actual language of Section 1 and how courts have interpreted that language. At the Section 1 stage, the burden of proof is on the state. So it is for the government to convince a court that any limit on a charter right is reasonable and demonstrably justified. Section 1 itself says that a reasonable limit is prescribed by law. This ensures that any limits on charter rights are traceable to an actual legal rule. That rule can be found in statute or regulation, or more rarely at common law. This ensures that limits on charter rights are consistent with the rule of law, which guarantees that all state power is itself authorized by law. Once you start to drill down into whether a limit on a right is reasonable, there are a number of factors that a state will have to address. That the limit on the right is for a pressing and substantial objective, that the limit is rationally connected to achieving that objective, that the limit minimally impairs the charter right in question, and that there is overall proportionality between the positive or salutary effects of the limit and the negative or deleterious effects on the individual whose charter rights have been infringed. While Section 1 is a legal tool designed to promote consistency in how the charter applies, it's important to recognize that charter rights are implicated in extremely diverse situations of varying complexity. It's also useful to recognize that there is a sometimes delicate relationship between the courts and the state when assessing whether a Section 1 justification has been demonstrated. To that end, the courts have repeatedly stated that the analysis of Section 1 is contextual. It will look closely at the circumstances. While the state must prove its case under Section 1, courts also recognize that it is not always possible to do so to a particular degree of scientific or forensic certainty. This may be because the particular objective really isn't amenable to scientific proof, or because the state is operating in a situation where information is simply not yet available or is uncertain. While purely speculative arguments are likely to fail, the courts do tend to give the state a certain margin in which to establish justification under Section 1, again, depending on the context. The final point I would make here is that it's natural to see the state and individual or citizens in an oppositional, even antagonistic relationship. This is particularly true for some contexts like criminal law, where you have the immense power of the state being brought to bear against a single individual. But sometimes the state is in a different position. It may be trying to balance competing charter rights. It may be trying to protect the vulnerable. Or it may be trying to safeguard certain things or values that in themselves are essential to a free and democratic society. All of those factors may be important to the ultimate assessment of whether Section 1 has been made out.
Thank you very much, Professor Mathen. Does another panelist wish to add anything at this introductory level, our sort of charter primer, so to speak? Professor Moon?
Well, maybe is this on? I can't. Yes, it sounds like it's on. Just add, that was, a terrific introduction. Just add one thing, because I'm struck that often individuals make claims. I have a right to something and make claims at large. And I think it's worth thinking about and noting what's in the Charter and what's not in the Charter. And the Charter, in a sense, performs two functions. One is a symbolic function, and it's meant to list what we understand to be the fundamental rights of members of the political or national community. But it also has a very practical function in the sense that there is an enforcement mechanism. That is to say, if someone feels their charter rights have been breached, they can make a claim before the courts. And that very much shapes what's in the Charter and how particular charter rights are, in fact, interpreted. the limits of what a court can do and how a court can approach or interpret a right. And I just think that's worth noting, given the general language it often operates about, I have a right, statements made very much at large.
Thank you, Professor Moon. Okay. Commissioner, we're going to move on. And so a few minutes from now, we're going to drill down more specifically on two of the fundamental freedoms, freedom of peaceful assembly in paragraph 2C of the Charter and freedom of expression in paragraph 2B. Still in a somewhat introductory mode, we're going to speak a little bit about those rights of democratic participation together, perhaps connecting them to fundamental values of public engagement and participatory democracy. And we're going to continue now with Professor Bird.
Thank you very much, Dean Leckie. So the topic of democratic participation, how and when individuals who belong to a democratic society contribute to the democratic governance of that society, raises several complicated and nuanced considerations. Participation in a democracy can take many forms: voting, running for office, writing to your elected representative, starting or joining a political advocacy group, and so forth. But for today, our focus is on protest as a form of participation in a liberal democracy, the idea of a right to protest in such a society, and when that right can or should be limited. So in these brief remarks, I'll offer some reflections on the added value of protest in a liberal democracy, leaving the matter of a legally protected right to protest and how that right can be limited for a later stage of our discussions. So it seems rather uncontroversial to suggest that protest in the form of rallies, marches, demonstrations, sit-ins, etc., is part and parcel of democratic life. Protest may at times test certain commitments that are said to be hallmarks of a liberal democracy, but I think it would be difficult to find widespread support for the notion that peaceful, nonviolent protest is untethered to democracy, or that this activity should be done away with as a form of democratic participation. And in general, I think the occurrence of protest is a marker of a vibrant democracy in which citizens are invested in how they're being governed and how their society ought to change. Even where protests might be a response to a perceived departure from democracy, these protests are still a form of democratic participation as they aim to perhaps rescue or preserve democracy and democratic institutions. Citizens coming together to publicly manifest their support for or opposition to this or that cause, issue, law, court decision, or some other current issue of public interest is a normal feature of democratic life. So much so that it would be perhaps unsettling from the perspective of a society's democratic credentials if protest were to become an endangered species of democratic participation and even extinct. And that idea invites us to think more about the added value of protest to our society, to a democracy. It's one thing to say that protests are commonplace and accepted as normal in a democratic society, but how do they enhance the practice or project of democracy? And perhaps history and hindsight might help us here. It wouldn't take too much time to be able to create a list of protests or activities akin to protests that were either instrumental in effecting transformative change for a society or significant from the perspective of raising within that society, and perhaps in other societies that take notice, of injustice, inequity, or violations of human dignity. So the civil rights movement in the United States, for example, comes quickly to mind. Now, scientific measurement of the effect of protests like these on the societies in which they occurred, as well as on the other societies that may have taken notice of those protests, is difficult to provide. But it seems fair to suggest that these and so many other protests over the course of history have accelerated the pace of change in hearts, minds, and laws alike. So the value of protest in the pursuit of a society that is more just, equitable, and protective of human dignity might be easier to perceive through the rearview mirror, so to speak, but we can choose to apply these lessons of the past to protests we witnessed during our lifetime. The protests we ourselves witness could be part of a longer arc of positive change that is not entirely perceptible to us at the time the protest is occurring. They may also turn out not to be part of that kind of change, but our inability to definitively know either way when the protest is underway suggests that we should perhaps err on the side of permitting protest. Still, some of us might say that instead of protesting, we should opt for less disruptive and disconcerting forms of democratic participation, voting in elections, writing to your elected representative, publishing an opinion article in the newspaper, launching media campaigns for a cause, and so on. And one response to this proposal would be that protest, owing precisely to its uniquely disruptive and perhaps disconcerting characteristics, may in certain cases be far more effective than other methods of democratic participation. It may even be true that in certain cases, protest is the only method that stands any chance of sparking the change that is desired. It's hard to imagine, perhaps, the civil rights movement in the United States of having succeeded simply through writing letters to members of Congress. Protest, in other words, might be the only meaningful way for certain voices and the message they carry to be heard by individuals in the halls of power. Without protest, the desired change might take longer to come about, in the order of years, decades, and even longer, or the desired change might never come about. Much more could be said about the added value of protest to democracy, not to mention the value of protest to the human condition and spirit, but for the sake of time, I'll mention only one more now. It could be called the pressure cooker rationale, allowing citizens to come together to peacefully express discontent over how their society or other societies are governed, allows these citizens, and even those citizens who agree with the protest but can only watch on television or social media, to let off steam and be heard. Forbidding or unduly expressing this outlet for citizens might sooner or later cause the pressure cooker to explode. Just to close, perhaps the greatest obstacle to appreciating the democratic value of protest is our own personal opinions on the aim or cause of a particular protest. When we disagree with the viewpoint animating the protest of the day, our opinion of protest as a form of democratic participation may also diminish. And the reverse also might be true. When we agree with the complaints of the protesters, our affinity for protest itself may increase as well. And this dynamic seems to come to the surface when we opine on how long a given protest should be allowed to last, or the degree to which restrictions should be imposed on the time, manner, and place of the protest. I suspect we often afford more or less latitude on these points, depending on how sympathetic we are to the views animating the protest at issue. And to close, I would just note that it takes a major dose of even-handedness and tolerance to express support for peaceful protest, even when we vehemently disagree with the reason for this or that protest or the views that the members of the protest hold. And yet, in Canada, this ideal, this even-handedness and tolerance, seems to be our aim in a free and democratic society, committed to maintaining a public square that is open to all its citizens and, apart from exceptional circumstances, the unhindered expression of their core convictions. So I hope these reflections will aid our conversation today as we explore how protest is and should be protected as well as limited under Canadian law. Thank you very much.
Thank you, Professor Bird. I wondered if any panelists wanted to comment on the particular contributions, if any particular protests in recent years, qu'il s'agisse du printemps d'érable ou quelque chose d'autre comme cela, at this stage. Does anyone want to jump in on a particular? I have another. After that, we'll move to the connection, perhaps, between a couple of the democratic rights of participation. Professor Cameron?
Yes, thank you, Dean Leckie. I would just draw attention to the pedigree and lineage of protest movements in history. So not expressly to answer your question, but just to point out, if we're looking at the United States, for example, we go back to the time before the Civil War and to the whole abolitionist movement, followed by the women's movements, and then up into the civil rights movement, which has been mentioned by Professor Bird, as well as Vietnam protest and any number of others. In our own country, just in recent years, we have seen Maple Spring, of course, the Occupy movement, Black Lives Matter, Idle No More, Pride movements, and all the Indigenous movements, which are too numerous to mention, but just to say that we have a very strong pedigree of protest movements in North America and including in Canada. And they're an important aspect, I agree with Professor Bird, very important aspect of participatory democracy.
Thank you, Professor Cameron. That makes a little more concrete Professor Bird's reminder that protests may not be simply something to be tolerated, but that they bring a distinctive value. Professor McDonnell?
I was just going to add that I think that you've both captured very well the sort of value of protest in a democratic society and the importance of nurturing it. My sense is that where the challenge lies is in, first defining the contours of a right to peaceful assembly, but then also sorting out how the state should respond when a protest implicates the rights of others. And so I think there is a wide degree of consensus on the value of protest in a democratic society. What becomes genuinely challenging is how the state responds in circumstances where parts or all of a protest become violent, where a protest interferes to some degree or to a substantial degree with the security and safety of others. And so I think the real challenge for decision makers, whether that's the state in the first instance or a court on judicial review or an inquiry reviewing these matters, is how do we do what Professor Mathin alluded to in her discussion of Section 1, which is how do we balance the competing rights and interests that are at stake in the context of a public protest. And to me, that's where the difficult work is.
Thank you, Professor McDonnell. Professor Moon?
Yeah, I think, and I know this, comes up in the various presentations, we have to recognize that any kind of protest is invariably disruptive. It will, to some extent, interfere with the ordinary use of spaces, people's ordinary lives. And so again, I agree, the challenge is to determine what is the outer limit of that? When does it become too disruptive, either as a matter of how much space is taken up or how long it's going on or how confrontational it is? And there is no simple answer to that. I think that's the real problem. One can think of the Occupy movement, for example, which involved the establishment of encampments that were there for an indefinite period of time. At least that seemed to be the plan. Everybody accepted that it was an important protest and that there was a right to be located there for a period of time. But then the question became, well, how long is too long? And again, there's no simple answer to that question.
Thank you, Professor Moon. Part of the challenge of construing a Bill of Rights such as the Canadian Charter is seeking to identify the relationship between the different guarantees. And at times we see from the claims brought in court that there's a perception that multiple guarantees may be engaged by a similar set of facts. But nonetheless, conceptually, it can be helpful to try to distinguish the different guarantees. And in the discussion so far, we've been touching, I think, on peaceful assembly and perhaps freedom of expression. Does any panelist want to prepare us for the challenge of articulating or separating those two before we go into them one by one? Professor Cameron?
Well, I think that was part of what I had been planning to say. I can do it up front if that's preferable. So I guess I would say that the fundamental freedoms overlap and complement each other, and that you couldn't have a viable freedom of peaceful assembly without also respecting protections for freedom of expression, and I guess, incidentally, freedom of association. So they work together and they have to all be protected, but I would also say that freedom of peaceful assembly is a distinct and independent guarantee that is not the same as freedom of expression. And so I can go into that in a tiny bit more detail. Freedom of peaceful assembly is a collective entitlement. It's an exercise of solidarity by a group of two or more individuals. The Supreme Court of Canada has acknowledged as much. It hasn't discussed Section 2C very much, but it has acknowledged that it is a group activity that is incapable of individual performance. So we tend to think of Section 2B, freedom of expression, as being an individual entitlement, and perhaps Section 2C is as well, but it's one that is exercised in collective in a collective way as an embodiment. I think that also it's important to note about freedom of peaceful assembly that it has an embodiment and a presence that is usually spatial in nature. Not necessarily the case with freedom of expression. And then assembly is also, I'll use this word, it's performative in nature, in the sense that what you have with an assembly is more than verbal expression. And whether the assembly is passive, like forms of assembly can be completely passive, that can be the message. And assembly can also be active and indeed very active. But what this tells us is that the act of assembling itself has a performative nature and a meaning that is not captured by Section 2B's freedom of expression. And therefore, it would be a mistake to collapse Section 2C and the right of peaceful assembly into Section 2B and treat assembly events as belonging under Section 2B rather than having their own independent entitlement. And so, from my point of view anyway, it's very important to separate Section 2C from Section 2B and begin the task of giving it definition and interpretation. So I don't know if others have comments on that. But.
Thank you. So you're, Professor Cameron, you're laying the groundwork for us to move in a moment to go a little deeper into looking at freedom of peaceful assembly, which, as you note, has been construed less by our courts than have others, freedom of religion, freedom of expression. At the level of the rights of democratic participation together, is there a final thought from anyone? Okay, so we're going to go back to Professor Cameron to pursue our reflections on freedom of peaceful assembly.
Don't worry, Dean Leckie, this is where it gets lively. Okay, so the Charter's guarantee of peaceful assembly has been mostly inert for the first 40 years of the Charter's interpretation. There's been very little in the jurisprudence, and apart from a mention by the Supreme Court that I noted a moment ago, has had very little interpretation or discussion at the Supreme Court level. And this might seem surprising, given what we've just heard from Professor Bird and others about the importance of public protests and public gatherings and their value as a form of participatory democracy. And I think it's clear that the Charter's fundamental freedoms and peaceful assembly do form a vital background to the Commission's work. So some may know that I did write a commission paper for the Commission on peaceful assembly. It's on the website. And the purpose of that paper, at least from my point of view, was to bring peaceful assembly into the conversation. And the paper, therefore, does not discuss the convoy or make any assessment of convoy activities, but its objective instead was to propose an approach to Section 2C. So here I think I'll quickly just make 2 or 3 points and then move the discussion back to colleagues who I know would like to weigh in on how we look at peaceful assembly. So I've already spoken about peaceful assembly as an independent guarantee of the Charter, and I've spoken about the importance of recognizing that entitlement and giving it its own place in the Charter. That was point number 1 in my presentation. So I'll move to the second point, and we heard about the structure of the Charter from Professors McDonnell and Mathen, and I think I'm going to start there because it's very important. When we start to take a look at Section 2C, it's very important to have that structural framework in mind. And as Professor McDonnell told us, there are 2 steps in any Charter analysis. The first step is to look at the nature of the entitlement and to give that entitlement a definition or interpretation. And then the second task is under Section 1 is to determine what limits are reasonable, what limits on that Charter entitlement are reasonable.
Professor Cameron, this is super valuable stuff. If you could slow down just a little bit, it would help the interpreters. and the broadest audience you deserve for this.
My apologies. Should I go back over
No,
any
no,
of that?
but just a
Okay.
tiny bit slower.
All right. So then looking at that structure reinforces the view that peaceful assembly, like the other fundamental freedoms under Section 2 of the Charter, should receive a generous interpretation. And so that means that questions about limits on peaceful assembly, for the most part, should be found and imposed under Section 1 rather than introduced into the preliminary definition of the entitlement. And in other words, peaceful assembly should be given broad coverage and limits to deal with disruption, disturbance, those kinds of issues should, for the most part, be reserved for Section 1. That's the setup and the nature and the concept of the Charter. So moving to Section 2C specifically, the central question under Section 2C, I think it's fair to say, is what is the meaning of peaceful assembly? What does it mean to say that an assembly is peaceful in nature? So what is peaceful under Section 2C and what is not? And I think there are going to be different views on this. And I'll just tell you a couple that I encountered in preparing the paper. And I'll say first that how you answer that question, how you decide what peaceful means for purposes of Section 2C will have dramatic consequences for the scope of the entitlement. So it's the critical issue under Section 2C. It is the critical issue for peaceful assembly, for that entitlement. So one approach to the question of what is peaceful equates peaceful assembly with nonviolent assembly. And under this view, assemblies are considered peaceful unless they engage in acts or threats of violence. It doesn't mean that limits can't be imposed under Section 1, but it means that an assembly has prima facie or preliminary status under the Charter as long as it does not engage in any violent activities. That's one view. It's not the only view. There's a different approach, sees it a different way, and would interpret the meaning of peaceful assembly quite differently. So under that view, an assembly is not peaceful or non-peaceful when it does any of the following, like cause a disturbance, engage in disruptive activity, engage in objectionable conduct, and even violate bylaws and other kinds of legal regulations. So on that view, an assembly would become non-peaceful when it reaches a sufficient threshold on any of these criteria. And under that view, it would mean that the assembly does not have any protection under the Charter. The difficulty with that view, in my opinion, is that it creates a risk of prematurely or preemptively shutting down public gatherings or demonstrations because they are considered or experienced as being objectionable in nature. And the risk is that the messages of the dissidents and vulnerable will be too quickly cut off. Now, we don't have a lot to go on in Canada. We do not have any Section 2B jurisprudence to speak of, much less a robust jurisprudence. But The international jurisprudence on these issues is quite striking because under the international guarantees, peaceful assembly is protected up to the point of violence. And the issues about disturbance, disruption, commission of unlawful conduct, etc., are matters of limits under their version of Section 1 or proportionality, but not of initial entitlement. I'm going to mention a third approach, and I'm going to give a bit of a shout out to the City of Ottawa, who provided, the City of Ottawa presented a brief in response to my paper, and it's a thoughtful response. The City of Ottawa, as I understand their response, proposed a harm test for Section 2C. So the idea was that violence is at one end of the spectrum, disruption considered still a form of peaceful assembly is at the other, and the city placed harm as a test sort of between the two. And the idea of it is that once a certain threshold of harm is reached in the activities of an assembly, that will forfeit the protection under Section 2C. So that was proposed as an alternative to these other two understandings of peaceful assembly. I guess I would say that it's difficult for me to agree with the City of Ottawa, although I think the proposal is certainly worth discussing. It's difficult for me to agree with that because harm is a very subjective and evidence-based concept, and it's better suited to the kind of analysis that is typically done in Section 2 cases under Section 1. So I would see a harm analysis under Section 2 as being out of keeping with the way Section 2 analysis is done generally in Section 2 cases. And again, a malleable concept of harm runs the risk of preempting assemblies that are engaged in participatory democracy. I'm coming to pretty much my last point about Section 2C, because I know we want to open the discussion up. And this is also a really important point, I think. We need to think about the relationship between the assembly per se and the individuals who are participating in the assembly. So I've mentioned that the assembly is conceptualized as a collective entity, but the collective entity, incorporates various numbers of individuals. The constituent participants in an assembly remain responsible for their actions. So, for instance, if members of a public demonstration or protest engage in unlawful conduct and even violate the criminal code, they are responsible in their individual right for their actions. They're responsible for any unlawful conduct they may commit. But generally speaking, and it's subject to evidence, of course, generally speaking, the acts of individuals do not taint or compromise an assembly, unless those acts become so pronounced or so pervasive that they come to define or characterize the assembly. At that point, they become the assembly, and that may change the status of the assembly under Section 2C. I think I've given us some things to think about. I'm going to make one final comment, and it is a little bit about this particular demonstration, but just to illustrate, I guess it would be my view that the assembly in this instance began at the point when the convoy set out from British Columbia at the start of the convoy. Trucks were at that point integral to the assembly, and it was for many days, it was a moving assembly. It was an assembly that moved across the highways in Canada before arriving in Ottawa. When it arrived in Ottawa, it became static and embedded. The trucks may still have been part of the assembly, but maybe their role changed. And maybe their presence in Ottawa changed and even escalated the nature and scale of the assembly. I think it would be fair to say, and I hope I'm not overreaching, Mr. Commissioner, I think it would be fair to say that the trucks compounded and intensified the disruption. But what I would say is that on a principled approach to the structure of the Charter, those issues inform the analysis under Section 1 rather than the scope of entitlement under Section 2C. And I have things to say about reasonable limits, but I think I've spoken enough and would love to hear from my colleagues.
Thank you very much, Professor Cameron. So just to situate your very helpful comments for the audience here, you were really focusing at defining peaceful assembly at the paragraph 2C level, basically bracketing for other discussion the question of reasonable limits on peaceful assembly under Section 1. And you were very helpfully, I think, focusing on the qualifying adjective peaceful, and it's 2C is distinctive in that the other fundamental freedoms don't have a qualifying adjective. So we have the right to freedom of religion with no adjective, freedom of expression, freedom of association without a qualifying adjective. So it's a real invitation to understand what that peaceful is doing there. And you've invited us to think about the three approaches there. I remember from our preliminary discussion with several panelists that may also be questions about even what an assembly is and to what extent an assembly is focused on natural persons and appendages immediately within their control versus larger dimensions. But let's open things up. I think Professor Mathen, you had some thoughts to share on this one too.
I do, thank you. And I really enjoyed the policy paper prepared by Professor Cameron, and I just do have a few observations that build on the paper. So the first point is I entirely agree that we do need to recognize assembly as an important fundamental freedom in its own right, and particularly in the relationship with expression, while they overlap, they do reflect different components of a free and democratic society. To that end, though, when we think about assembly, as Dean Leckie has just noted, it does have this, what we call an internal limit, an internal qualifier, which is the word peaceful, which is not, we do not see that with the other fundamental freedoms, and so our analysis needs to take some account of that. In terms of looking at the right itself, while it often is associated with meaningful activity, I think we might want to be careful that we don't only see assembly as oriented towards conveying meaning, because it is a physical activity. It can be addressed towards some other goal that is not closely related to conveying meaning. For example, an assembly could be oriented towards protection of an individual or a place that is really its own goal, separate from any conveyance of meaning to other people. In terms of the word peaceful, I think here as well it is important to recognize something that distinguishes assembly from the other fundamental freedoms, which is that it is commonly manifested in a physical way. So it is the coming together of people, and it is that physicality that historically, of course, has been seen as very important. But that also makes assembly different from the other fundamental freedoms. And so when we think of the limits on peaceful, I think that the borrowing from expression of the freedom of expression, of the notion of violence as being an important qualifier, is absolutely appropriate. The Supreme Court of Canada has recognized that threats of violence are not protected under freedom of expression. I would certainly, suggest we could think about whether that's appropriate for freedom of expression, for freedom of assembly. But in addition, how we assess what the threat is, I think, may require a slightly different vantage point, which is that I think it is useful to consider using an objective analysis of the threat posed by a particular assembly that may take it out of the protected sphere of being peaceful. So this is not dependent on proving the violent intentions of any one of a number of the members of the protest, which I think is first of all, can be extremely difficult to do, but also does not sufficiently engage with the nature of the protest as a whole. So this is not a numbers game. This is a very fact and context sensitive assessment of what the assembly is or is becoming. It might also be interesting to consider, just as there is a right against forced expression, is there a right against forced assembly? And again, because of the physical manifestation of assembly, are there circumstances in which people might be involuntarily brought into the context of the assembly? And this might particularly be the case where the nature of the assembly is such that it actually affects the person in their primary residence, so that in order to escape the effects of the assembly, they must leave their residence. Is there a question about whether you are in that context, perhaps dealing with involuntary or forced assembly? Dean Leckie noted the very interesting question of what the actual fundamental freedom includes in terms of whether it is just human bodies or other things. And that, I think, was very much brought out in the current situation that we're considering. And the one point I would make there is that, and this is not, I would think, as to whether the assembly is peaceful, but whether it is actually a protected exercise of assembly. We just want to be careful that we don't overread the right of assembly so that it privileges those who have more resources to effect an assembly that becomes more difficult to control. So I would just perhaps suggest that that might be something to think about. And then finally, when we get to the justification section under Section 1, certainly the state should be cautious about simply dispersing an assembly. I believe in international law that is seen as a last resort. But in some contexts, dealing with the assembly more rapidly may actually create the space for maximum enjoyment of the right of assembly going forward, as opposed to, because of this very, I think, appropriate reluctance to interfere with the assembly, what you wind up producing is a situation of an entrenched assembly that then has to be dealt with in a much more intrusive way. So I'll stop there.
Comments from other panelists at this point? Professor Moon and then Professor Bird. Professor Moon.
Okay, thanks. Just a brief comment. Professor Cameron's paper is a terrific paper and really outlines a very strong argument. I want to take not exactly issue with it and some of what Professor Mathen has said, I almost got that wrong. And I want to kind of reassert that what I think is the significant overlap between the different rights. It's really important to remember when talking about freedom of religion, for example, it has a collective dimension. It protects religious rituals, manifestations of religious practice, often which occur in collective form. And so it does have a physical dimension to it in that sense. And the same could be said about freedom of expression. Expression occurs in a variety of ways. I'll say something more about that in a minute. But it's always physical, even in the most minimal sense of using one's vocal cord, but more often involves much more than that. So I want to re-emphasize that all of these rights have a physical dimension to them. All of them have a collective dimension to them as well.
Thank you, Professor Moon. Professor Bird.
Just a couple of quick comments. Thank you, Professor Math and Professor Cameron, for all the comments so far. In listening to more recent remarks, it does seem to me that this addition of this adjective of peaceful, I've so far drawn to this notion that perhaps the drafters are trying to point us to, in a way, what it doesn't protect. And in that, just thinking of the kind of natural antonym of peaceful being violent or violence, so it doesn't protect violent assembly. But I need to think more about this, and the comments are making me think more about that. One thing I would also note that this approach has been suggested by the City of Ottawa, perhaps using harm and as a kind of a way to assess whether the assembly is protected or not. It does seem to me that, at least just from an application perspective, that determining what's violent as opposed to non-violent seems to be a bit more manageable or easier to identify, perhaps, than harmful versus not harmful. So even from in addition to the kind of just the linguistic, the text, what it may be pointing us to what the protection does not cover. I'm also drawn to the notion that harm is just indeed has seemed to be a very difficult or can be a challenging concept to apply, whereas violent versus non-violent seems to be maybe a bit of a brighter line. But I just wanted to mention on the Section 1 standpoint, this idea of limiting peaceful assembly, just given what has been said so far about the value of assembly and protest to democratic participation, one of the lesser kind of interpreted phrases in Section 1 is this idea of a free and democratic society, this notion that all rights and freedoms in the Charter can be limited when those limits are prescribed by law, when they're reasonable limits, and then finally when they're demonstrably justified in a free and democratic society. Perhaps this discussion also invites us to think more about what that phrase, free and democratic society, especially the democratic part, means in terms of, does that somehow animate the threshold or the bar which the state needs to reach? And even the word free as well, given that that word points to, has a particular resonance with freedom in the fundamental freedom. So just maybe thinking a bit down the road of our discussion of Section 1, that phrase of free and democratic society seems to potentially have a lot of, may have much to say, or a lot to say in this context. I'll just pause there.
Professor McDonnell's next, and then we'll go to Professor Cameron. Professor McDonnell.
Just a short point on this question of reasonable limits on freedom of peaceful assembly. I think in thinking about reasonable limits, it would be helpful for us to try to move beyond what I think is a very common binary in our thinking about protests, which is you either allow the protest to continue or you shut the protest down. And one of the important components of the Section 1 analysis is to examine whether a limit on rights is minimally impairing, whether it impairs no more than is required to meet its objective. And it seems to me that there are, points on the spectrum that our discussion often fails to capture. And so you do see, if you look at the very little bit of case law that there is on freedom of peaceful assembly in Canada, that one option is to allow an assembly to continue during specified hours or under different conditions than the assembly. Than the conditions that originally surrounded the assembly. And so to me, this sort of moves our discussion away from either full protection of this right or sort of full violation of this right to a space where we can consider, is there a way to still give meaningful effect to freedom of assembly, while also recognizing that, as Professor Moon said, as time goes on, if there are elements that are potentially violent or, highly disruptive to the safety and security of others, are there options there that still allow for substantial preservation of the right?
That's very interesting, Professor McDonnell, given Professor Cameron's point that dispersal is the absolute last resort, right, but it's not the first mode of intervention. Professor Cameron.
Yes, just thank you, Dean Leckie. Just a couple of follow-up points. On the issue of acts or threats of violence, I think that it's helpful to think about the nature and the level of the threats, to ask where they're coming from, who is making those threats, if any, and how pervasive they are. Because the threats will typically be made by individuals rather than the assembly. And, the entitlement belongs to the Assembly. So we have to be careful not to treat levels of disruption as threats in and of themselves, because to do so risks excluding certain assemblies and gatherings from Section 2C and not granting them any charter protection at all. So I would always argue that those kinds of limits can be imposed under Section 1. So it's evidence-based, whether there are threats, whether they're sufficient to compromise assembly. A second point has to do with Dean Lecky's observation, and I guess a discussion we had at dinner last night, which is what exactly is the assembly and what kinds of props that may be used or by an assembly are included in the entitlement. And so we specifically had a question about trucks last night and whether they are part of the assembly. But there are other kinds of examples, of course, so that assemblies choose the way and means that their message can be effective. So they will typically, or they may use all different kinds of props. And they can be quite innocuous in nature, the props that are used by assemblies, but they can go all the way down to the use of weapons and so forth. So the question there is, to what extent does the right of peaceful assembly include the choice of means and the choice of props and structures, including not just camps and entitlement and tents and camps and so on, but things like trucks. And a final point just has to do with the relationship between Section 2C and Section 1. I think, we may have reasonable disagreements about whether the work can be done under Section 2C or whether it should be reserved to Section 1. One of the reasons I support the Section 1 approach is that for the reasons that were just mentioned, that it's not an all or nothing kind of a calculation. There may be ways for an assembly to continue in a proportional way with the imposition of limits that carefully balance the rights of the community. I think I'll stop there. Thank you.
Thank you. Professor Mathen.
Thank you very much. It's just a brief point to just to clarify perhaps the issue around threats of violence. And I just want to be clear that I am here talking about violence against the person. So the classic criminal understanding of violence against the person. So that is interference with people. Those are the kinds of threats I was talking about, not other forms of disruption. But there can be, on an objective basis, an assessment that the nature of an assembly creates a reasonable generalized threat to people who are within the immediate vicinity of that assembly. It will be very much fact specific.
Thank you. It's also interesting to grapple with the question, at what point do individual members of the Assembly start to characterize the thing as a whole, such that we feel that the Assembly itself is involved in conduct of that nature. One of the questions submitted in advance to us concerns specifically Canada's Indigenous peoples. And so I wondered if panelists had thoughts on whether the fundamental freedoms of Indigenous peoples differ from those of others, particularly when they involve social movements seeking to promote recognition and respect for traditional territories, lands, and resources. And a more specific form of that question, should the charter protections for assembly and protest be interpreted consistent with the rights of Indigenous peoples? And is Section 25 of the Charter any help in this regard, so that limits imposed on those fundamental freedoms do not restrict Indigenous peoples from obtaining redress for historic and ongoing violations and denial of their rights? Anyone wanting to take that one on?
I can just say a
Professor
few words.
Gautreau-Desbiens.
If we look at the case law of the Supreme Court, for example, on freedom of expression, we realize that when the court looks at Section 1 and at the justifications that are invoked to defend some measures, potentially restricting freedom of expression, it's a context-based analysis which takes into consideration particular situations. Example, the cases involving the Charter of French Language in Quebec. The analysis that was made by the Supreme Court was responsive to the particular context of the French language in the province of Quebec. So under Section 1, I don't see why cases involving the fundamental freedoms of Aboriginal people should not be treated in the same sensitive way. Canada is a very diverse country, and in many cases, the Supreme Court has clearly taken into consideration differences. For another case involving Quebec, where the particular regime of and history of labor relations in the province was taken into consideration, absent this consideration of the particular context of the province, would the decision have been the same? I don't know, but being context sensitive, as the court has been in its application, its interpretation of fundamental freedom, and the evaluation of their reasonable limitation, is part and parcel of our case law and of our constitutional law. So I don't see any fundamental problem in being context sensitive to the claims of Aboriginal people and their rights.
Thank you. Commissioner.
Yeah, I just want to, not on this last point, but go back to a point that Professor Mathen was raising, and that's about peaceful assembly and the question of whether it's a matter of violence or threatening. And I think threatening is very relevant if in this case, because we heard a lot of evidence about people who felt threatened by the fact that there was all this gas around and they were scared for their life, arguably. There were people who would not walk to work because they felt threatened. And there were businesses who closed because of the threat of mask removal and so on. So leaving aside whether those facts are established or not, which is a dispute, and leaving aside really whether that's a group of individuals or not that were causing it, I'm quite interested in exploring a little more that concept, because whether that means it's a Section 1 or whether it's the assembly is peaceful. And I think the peaceful is if violence is the only thing that makes it non-peaceful, that's one thing. Although I don't think that's a big limitation, given that violence is illegal per se, and when is the assembly violent would be hard to define in any event. But so that would be helpful for me, and because I think that's part of the concept that is being developed.
Thank you, Commissioner. And just before we go back to the panelists, I would just add to that, if I might. I'm wondering if anyone else wishes to take up Professor Mathen's suggestion that at a certain moment, an assembly is actually conscripting other people into participating in it by being, in their neighborhood all the time or something like that. And so we know in other contexts that one is not allowed to impose one's religion on others, that one has a certain right not to be in an association. And so I'm wondering if anyone else finds it helpful as a distinct question from whether violence has occurred to say at a certain point, I have no choice but to be part of this assembly. And does that help us see a limit on the right to peaceful assembly? Now, Professor McDonnell was already on my list, and I see Professor Cameron will follow her.
I was on the list for a slightly slightly different point. So perhaps I'll just cede my time to
Sure.
Mr. Cameron.
Professor Cameron?
Okay, so just a couple of points, if I can read my writing. Thank you, Mr. Moderator. So I think there's a difference between threats of violence being made and the community's experience of feeling threatened by the presence of a gathering or a demonstration. And so again, in the spirit of not preempting a fundamental charter entitlement, I would say that that experience of feeling threatened can definitely be addressed. And there's nothing to say that it doesn't allow limits. But my view would be that that belongs under Section 1 rather than Section 2. I think also, again, with a second point, I'm not sure this is responsive or not, but it's a messy situation, isn't it? Because you have an assembly that can be sort of inchoate, and you don't really know what is the who is the assembly, what is the assembly proper, and who are the interveners, and to what extent is the burden on the state and authorities to separate out those who have gone rogue or engaged in their own activities of unlawful conduct? I think that's a difficult question. Again, the concern would be not to preempt the entitlement needlessly unless the evidence permits a conclusion that the assembly has itself attained violent dimensions. And then a third point was about being conscripted, but I'm going to pass so that others can speak.
Professor Bird, and then Professor Mathen.
Maybe just on the conscription point, or imposing one's assembly on another, it does seem to me that the built into the protection of the guarantee is this notion of kind of voluntary assembly, of you wanting to be of your own free will and not under duress or not coerced or conscripted, being a member of that. So I think the notion of not imposing one's religion on another in terms of the freedom of religion context does seem to have a lot of purchase here as well. On the question of threats of violence, strikes me that if an assembly is occurring and it's public and the authorities are aware, of course, can monitor for prospects of violence. Is there a point at which the threats of violence have transformed into where the violence is inevitable? The authorities know that it's going to occur. Maybe they have intelligence that they know that it's going to occur start at a certain date and time, or they have very strong evidence or objective grounds for that. You could arguably say at that point that maybe it is now no longer peaceful, such that it's no longer captured by the guarantee. Alternatively, it could be seen as still being peaceful because the violence hasn't yet started, and any kind of intervention, which might well be justifiable to avoid what is violence that is forecasted to start, would be indeed a limit on a still peaceful assembly, but one that would be considered under Section 1. So I'll just pause there.
Thank you. Professor Mathen.
Thank you. I think a really important point about freedom of peaceful assembly and I take Professor Moon's point that there are aspects that are common to all the fundamental freedoms, but linked to Professor Bird's discussion of democratic participation is the very important component of mutuality among citizens when they are confronting the kinds of issues that arise that will be the subject of some exercises of peaceful assembly. And so that mutuality, I think, is very important. And it's in that context as well that it becomes important to assess the overall nature of the assembly, which may be very messy, which may have inchoate or unknown leadership, which may have multiple assemblies. But from the objective point of view, that doesn't make it impossible or indeed remove the need to arrive at an assessment of what the assembly is and the potential risk of interference or level of interference with other citizens that, again, takes it out of that umbrella of being a peaceful assembly protected by the Charter, consistent with the underlying norms and purposes of the Charter that warrant this constitutional protection.
Thank you. Other thoughts from the panelists?
Just
Professor Cameron.
just one tiny point, which is what Professor Mathen is speaking to, I think, is the coercive properties of demonstration in certain circumstances. And I guess I'm just thinking through, and I don't have anything further to say at the moment, but there may be a difference between something that is sort of a coercive presence versus a threatening presence. And, you know, it's a point to sort out.
Thank you. Professor McDonnell.
One small point just in making this, you know, sort of factual assessment of the nature of an assembly. I think that that social media makes this more difficult in some ways because Professor Bird talked about, you know, what police intelligence might be available. Is there national security intelligence that's available? You know, I think there's also this question of how the protest is understood in the public, in the media. And on social media, there is the potential for a small number of leaders to really to be the face of a protest. And so I think one of the challenges in trying to make this objective determination is, you know, what matters? Is it what's happening on the ground? Is it what the, you know, the police information tells us? Is it what seems apparent on social media? And, you know, in many ways, the democratization of social media has been very positive. I think it can also, though, perhaps like skew our assessment one way or the other, frankly, in terms of trying to characterize the assembly as a whole. And given that this plays an important role in determining the scope of constitutional protection, I think that that is something worth reflecting on.
Professor Bird, just building on Professor McDonnell's point, I think that's very important. The kind of social media face or the media face of an assembly versus the true, potentially different kind of situation on the ground, or perhaps the skewing effect that you talked about seems a very important factor. And I just wanted to qualify my remarks a little bit before when I said that if threats of violence are risen to the level of now they're going to be inevitable, the violence is going to occur or is expected to occur, it may not be that it animates the entire assembly. It may be that, you know, out of an assembly of 1,000 people, there is evidence that 5 people, whatever the number might be, a very small percentage themselves are going to kind of go rogue, so to speak, and enter into violence, while the rest of the assembly has no interest in that whatsoever. So that's another part of the conclusion as well, is, you know, do you then have a more individual kind of focus and holding those individuals accountable and saying that the assembly still, by definition, is still peaceful? Or do you say that it's now become, in the grand scheme of things, an unpeaceful or non-peaceful assembly across the board? So that's another consideration to bear in mind.
Thank you. Commissioner, have we provided some help on the question you asked?
Yeah, some help, but it's still, I'm still troubled. I mean, to put it more dramatically or more sort of black and white, at sort of 10 o'clock on the Saturday of this demonstration, certain people have said it's an occupation. And so my question is really directed at that, and leaving aside whether that's a fair characterization, but a neighborhood was occupied. The police, to a large degree, were not pressing any charges, were not pursuing any complaints by the citizens of that area, and arguably there was no real violence in those areas that was reported. Let's assume that. So that's really my question, is you have an occupation of a neighborhood as opposed to a park, and you have people who legitimately, let's assume, and they've testified they felt threatened. You can't point to any violence. Do you have to go to Section 1, a reasonable limit, i.e., which is, I think, what Professor Cameron says, or is there something about peaceful assembly? No, you can't. It's not a peaceful assembly to occupy a neighborhood and basically where police can't enforce because they'll be swarmed. Again, you might say it's a few individuals, which no doubt it is. But I think that's a factual finding I may have to find, but it's, when I look at peaceful assembly, is that something that is peaceful? But again, I thank you for the comments, but I wanted to point out really what is a critical element in this is that occupation, as it's been described, where it's been said it's a lawless neighborhood in which people live, and no suggestion, let's say, of violence.
Thank you. The occupation question is one challenging thing. Last night in the discussion some of us had, there was also disagreement indeed over whether honking at a certain point becomes an assault. And is it, I mean, there is a physical dimension. Your body can experience noise if it's loud enough and sustained enough. And there are all kinds of norms around construction work and so on that recognize the impact on the person. Does that itself become unpeaceful at a certain moment? And I don't think of it as a political ideology, but whether you were in Ottawa last winter seems to affect a little bit how you approach some of these issues where conceptualizing and fact meet up. Professor McDonnell.
I was just going to add that one of the things that we have been discussing and will continue discussing in this conversation is the extent to which, because, as Professor Cameron points out, there is so little case law on freedom of peaceful assembly. When we're looking elsewhere for guidance, one of the places we tend to look is at the way that the court has addressed other fundamental freedoms. And here, on this question of violence or threats of violence, the freedom of expression jurisprudence has moved from saying that, it's only physical violence that is sort of excluded from freedom of expression where there is communicative content, to including threats of violence. And so in terms of thinking about what the scope of peaceful assembly would be, my sense is that's fairly strong authority for treating both threats of violence and actual violence as being not peaceful for the purpose of 2C. My sense is the question that comes out of some of the submissions of the parties and from some of the material that Professor Cameron canvasses in her paper is there something more than that, beyond threats of violence? Is there something about disruption, inconvenience, that also would take a protest outside of the scope of being peaceful? My impression, though, and perhaps this isn't shared by the panel, is that it would be surprising if a right to peaceful assembly did not take account of threats of violence, and that this standard for rendering a protest not peaceful is actual physical violence. I think that would be out of keeping with the kind of the freedom of expression jurisprudence and the direction it's taken for much the same reason, informed by much the same rationale as one would see in the context of peaceful assembly.
Colleagues, we're doing this collectively. We've spent longer on this issue than we'd expected, but I think it's valuable. So, Professor Moon, I'm happy to go to you next. We're all cognizant that this is shrinking a little bit freedom of expression, but I think this has been very fruitful so far.
I'll say very little.
Please continue.
I wanted to kind of work through the notion of occupying a neighborhood a little more closely, because if what we're talking about are public spaces, public properties, the streets, for example, as opposed to private properties, then it strikes me that there is at least initially a right to protest in those spaces. Obviously, the residential character of a particular neighborhood can certainly and should play a role in determining what's a reasonable limit on that. It's one thing to parade down a street in a residential neighborhood demonstrating. It's another to remain there for an extended period of time, to honk horns and whatever. And it strikes me that that's very much a question of what are the reasonable limits as opposed to something more basic.
Okay, so thank you very much for the exploration of freedom of peaceful assembly. We're going to turn now to freedom of expression, paragraph 2B of the Charter. We've already had the suggestion that there's continuity in the sense of potentially a collective and a physical dimension to this guarantee as well. But we're going to continue with Professor Moon.
All right, so I now have 2 minutes is what you're telling me.
No, you're good.
All right. Well, thank you. I'm, very pleased to be included in this. I almost feel like I should begin with an apology to the translators because I haven't often spoken to parliamentary committees, but on the few occasions I have, I've invariably been told to slow down. So I will at least try to begin. All right, so Section 2B of the Charter protects freedom of expression, but more fully, it protects freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. But I am going to simply speak about freedom of expression. It's generally understood that it matters, it's important as a fundamental right of freedom because it's necessary to the I know, it's, passion. It's necessary to the operation of a democratic form of government. It contributes significantly to the development of truth or the growth of individual or collective knowledge. And it's important to self-realization. I would add, though, I think it's important to keep in mind that freedom of expression doesn't just protect individual liberty in the sense of the individual's kind of personal, private space. It protects a social activity. It protects the right of an individual to speak to others and to hear what others may say. It's a social activity that invariably involves the use of collective resources, whether that be the parks, the streets, or the internet. And I think that's important to keep in mind. All right, the scope of freedom of expression. It protects communication, something along those lines. And what our courts have said, it protects any activity that is intended to convey meaning or a message to others. And I think it's worth noting that the court illustrates this with the example of parking against the rules. So ordinarily, if you park contrary to whatever the rules may be, presumably you do so because you don't want to pay, whatever might be the cost of doing so, or you can't find a convenient spot. But, says the court, if you park against the rules in order to protest in some way, then that counts as expression. Now, that suggests a fairly broad understanding of expression. In principle, any act can be an act of expression if performed with the intention of communicating a message. It also means that any law could, in theory, be a restriction on expression if it happens to restrict the way in which someone has chosen to express themselves. Now, the example given by the court refers to parking. Maybe it's convenient that we're thinking of cars, but we could, of course, think of other vehicles as well when thinking about acts of expression. As Professor McDonnell earlier referred to, the court, though, recognizing the potential breadth of the scope of this right, has said that it doesn't include acts of violence. That's what they said initially, and then subsequently said, and it doesn't include threats of violence as well. So if an act doesn't exclude advocacy of violence. I mean, that can be dealt with under Section 1 potentially, but from the scope of Section 2B, it only excludes acts that have the form of violence. So a terrorist act, some kind of physical violence directed at another, and threats to do so. All right, so the court has said that picketing, advertising, hate speech, obscenity are all fall within the scope of Section 2B, but of course are subject to reasonable limits under Section 1 of the Charter. I won't say anything more about Section 1 because it's been very well covered already. But maybe one thing worth noting is the court said with regard to freedom of expression, when we move on to Section 1 and considering limits, although all these different forms of expression are protected, some have more weight or more value than others when we are considering limits. So, for example, political speech, it's core value speech. It's closely, says the court, connected to the values that underlie our commitment to freedom of expression. And so it has a high value. It will be harder for the state to justify its restriction. On the other hand, hate speech, obscenity, commercial advertising are less directly connected to these values, and therefore it may be easier for the state to justify its restriction. Okay, I wanted to quickly talk about three issues, free speech issues, that might be worth considering. One of them is hate speech. And in Canada, hate speech is restricted under certain human rights codes, not all of them, and at the moment, not under the Canada Human Rights Act, but that may change at some point. And it's restricted, of course, under the Criminal Code, under Section 319(2), which prohibits the willful promotion of hatred against the members of certain identifiable groups. There are two kinds of harms that we can connect to hate speech. One of them is the harm directly experienced by members of a target group. Threats, intimidation, harassment, for example. And most of the US cases are about that kind of harm. The other kind of harm is the spread of hateful views within the larger community, so that some in the community may be persuaded by others to take a particular view about members of the group, with the result that those who hear these views may adopt more hateful attitudes or may even take action against the members of targeted groups. And most of the Canadian cases have been concerned with that kind of harm, with hate speech laws directed at that kind of harm. And our courts, in a number of cases...
About 2 minutes left.
Okay, I'll get there. So our courts have been willing to uphold these restrictions on hate speech, focusing primarily on the fact that the laws are very narrow in their scope, focusing on speech that is extreme, that is understood as vilifying the members of particular groups. Okay, I'll say no more about that then. Another issue that seems relevant is the question of the right of individuals to access government-owned property in order to communicate. I wrote about this fairly extensively in my background paper, and so I'll just boil it down to this. Our courts have said that there are really two kinds of state-owned properties. There are what might be called public arenas or public forums, properties that by tradition or in practice are generally open to the public for communication, and individuals have a prima facie right to enter onto those properties in order to communicate. Obviously, their expression can be restricted for a variety of reasons, but those reasons are not simply that the state owns the property and can exclude someone from it. And then there are other properties to which individuals don't ordinarily have the right to enter onto and communicate, and they are described as, paradoxically, sometimes private forums or something like that. And the state doesn't have to justify the exclusion of expression from those properties. So we're talking about government offices, broadcast facilities, properties of that kind. And then I guess finally, I just wanted to say a little bit about social media and the changes that it has brought to our thinking about freedom of expression. I think one change is speech that previously was not considered harmful, at least to a degree that might justify its general restriction, we now may be viewing differently. For example, disinformation or deceit, of course, has been subject to very particular restrictions in the past, false advertising, defamation, and so forth. But it has become such a large problem, I think we are having to think increasingly about whether or not there need to be larger restrictions or interventions on this form of speech. And I think the same could be said about speech that is insulting or harassing. It takes on a different character online when so many people can pile on, or it can be persistent, or the insult or harassment can be widespread and endure in many ways. And then finally, I just want, my final remark is to say, of course, what social media also means is that the traditional legal responses to these harms are increasingly impractical. They're too slow, they're too cumbersome to really address these. And that's why there is much more thought being given to how social media can itself be engaged in taking this material down. And that brings a range of different challenges.
Thank you. Thank you. And social media, and disinformation will come back a little later this week. Professor Gautreau-Desbiens.
Yes, thank you very much. For the sake of time, I will speak directly to one issue that Professor Moon raised, which is that of disinformation, false news. And since I had written my notes in French, I will switch to French. Alors, je veux simplement rappeler que, and please remind me to speak slowly. This has always been a challenge.
Avec vous.
Alors, il faut rappeler ici que la notion même de fausse nouvelle est ambiguë. Elle recouvre des réalités qui sont extrêmement différentes. Ça peut aller de représentations hyperboliques qui sont faites dans un but satirique à des mensonges qui sont énoncés ou des représentations qui sont fabriquées sciemment en vue de tromper. On sait que dans l'arrêt Zundel de 1993, la Cour suprême du Canada a invalidé une disposition qui pénalisait les fausses nouvelles et dont les origines remontaient au Moyen Âge. La Cour a à ce moment rappelé que les critères de la liberté d'expression mettent souvent en jeu une opposition entre l'opinion majoritaire au sujet de ce qui est vrai ou correct et une opinion minoritaire impopulaire. Et d'une certaine façon, en mettant en pratique l'esprit, l'éthique relativiste qui inspire le libéralisme, la juge McLachlan, telle qu'elle était à l'époque, nous expliquait que la liberté d'expression est une garantie qui sert à protéger le droit de la minorité d'exprimer son opinion, quelque impopulaire qu'elle puisse être, etc., etc., etc. Donc, elle voyait dans la justification de l'invalidation de cette criminalisation des fausses nouvelles un moyen de protéger l'opinion minoritaire. C'est donc le droit. Par ailleurs, il faut voir que le droit canadien n'impose pas en amont d'obligation de vérité à ceux qui s'expriment. Et c'est important de le dire dans le contexte d'une discussion juridique. Ce n'est qu'en aval, ex post facto, que le droit pourra rendre des personnes qui ne disent pas la vérité, dans des circonstances très bien balisées, des propos faux qu'ils ont tenus, comme par exemple en matière d'atteinte à la réputation. Une chose qui me paraît très, très importante de noter, c'est que l'écosystème expressif dans lequel nous évoluons depuis une vingtaine d'années, avec l'Internet, avec la montée en puissance des médias sociaux, ce n'est plus le même que celui dans lequel nous avons grosso modo vécu pendant 150 ans. Et Zundel a été prononcé dans cet autre monde, dans l'ancien monde, avant l'arrivée d'Internet et la montée en puissance de ce qu'un grand sociologue français, Pierre Rossan-Vallon, a appelé l'âge de la défiance par rapport à l'âge de la confiance. Alors, si on doit continuer de prendre au sérieux les préoccupations de la Cour suprême du Canada dans Zundel à propos de la complexité des fausses nouvelles, on doit quand même prendre acte du fait, comme le dit le professeur Moon dans son texte, son policy paper, que le cadre qui est mis en place paraît un petit peu daté et pourrait devenir une forme de cheval de Troie qui ferait obstacle à une appréhension véritablement complexe de ce nouvel écosystème normatif. En effet, la capacité de mobilisation et d'action autour de stratégies de désinformation a été décuplée, de telle sorte que toute analyse d'une manifestation comme celle sur laquelle se penche cette commission peut difficilement faire l'économie au moment d'émettre des recommandations de ce qui provoque en amont de telles manifestations et de ce qui va en provoquer d'autres. Comme l'a souligné mon collègue de l'Université de Montréal, Pierre Trudel, les différentes catégories de fausses nouvelles n'appellent pas toutes les mêmes interventions, alors que la capacité de distinguer les propos satiriques relève d'une stratégie de promotion de l'amélioration. Oui, I'm sorry. Relève d'une stratégie de promotion de l'amélioration des capacités de lecture des internautes. Lutter contre la falsification volontaire de l'information pourrait passer par des régulations plus fortes et plus conséquentes. Et là-dessus, il faut bien voir comment les réseaux sociaux fonctionnent, par des processus algorithmiques qui sont protégés par le secret commercial et qui sont le fondement du modèle d'affaires des réseaux sociaux. Et d'une certaine façon, on le sait très bien, on crée des bulles informationnelles qui créent non pas un choc d'idées, comme le veut la théorie classique en matière de liberté d'expression, mais plutôt des compartiments étanches entre des univers informationnels différents. Et le collègue en question, Trudel, suggère d'imposer à terme aux opérateurs des réseaux sociaux des obligations de transparence. D'un point de vue constitutionnel, évidemment, ce sera à la Cour de le faire en temps et lieu, je pense qu'il va falloir revisiter le cadre applicable à la saisie des fausses nouvelles. Peut-être via la reconnaissance d'un statut spécial à ce que la professeure Vicki Jackson de Harvard appelle les institutions du savoir, knowledge institutions, telles que les universités, les musées, les agences statistiques gouvernementales, mais qui transigent à distance du gouvernement, les tribunaux également. Donc, des acteurs sociaux qui ont comme objectif principal l'analyse ou le développement, selon évidemment leur fonction particulière, d'informations fiables qui sont produites ou qui sont filtrées selon des standards éprouvés et vérifiables. Et même si on peut dire que la distinction entre les faits et les valeurs n'a plus l'étanchéité qu'elle avait dans le passé, on doit réfléchir à ces questions-là. Et d'une certaine façon, j'ai peur de dire que notre droit constitutionnel en matière de liberté d'expression mérite d'arriver au 21e siècle. On n'y est peut-être pas encore. Le monde a changé et peut-être de revoir, même s'il se fonde sur des bases très, très solides, de revoir l'espèce d'angélisme relativiste qui l'a inspiré à bien des égards et qui nous faisait croire qu'en bout de ligne, la vérité allait triompher ou pouvait triompher. Je vais m'arrêter là pour l'instant. Parce que, bon, j'avais plein d'autres choses à dire sur la question de la propagande haineuse aussi. Alors, je vais le dire 30 secondes. Monsieur le doyen Lecky va me le permettre, j'espère. La criminalisation de la propagande haineuse au Canada se fait en fonction de variables identitaires. Autrement dit, la stigmatisation de groupes qui sont définis à partir d'une identité quelconque, le genre, l'orientation sexuelle, la race, l'ethnie, etc. Dans notre société où la polarisation politique est exacerbée, bien sûr qu'on retrouve beaucoup de cette propagande haineuse traditionnelle, mais il y a aussi une stigmatisation radicale et virulente des personnes qui participent à l'activité gouvernementale, qu'ils soient élus ou qu'ils fassent partie de l'exécutif. Ces personnes-là sont victimes d'attaques virulentes et parfois haineuses sur les réseaux sociaux en raison de la fonction qu'elles exercent au sein des institutions démocratiques. Et d'une certaine façon, là aussi, il va falloir se poser des questions. C'est évidemment pas la commission qui va régler ces questions, mais les législateurs vont devoir prendre ces choses-là au sérieux. Mais c'est tout cet écosystème expressif qui se met en place en amont et qui est très différent de ce qu'on connaissait auparavant, qui va favoriser l'émergence de mouvements sociaux, parfois violents, pas toujours, mais qui vont mobiliser des personnes et peut-être parfois les mener à poser des gestes collectifs qui vont prendre, qui en viennent à subvertir la démocratie, les processus démocratiques. Je m'arrête pour.
Merci beaucoup. Il se peut aussi qu'il y ait une dimension intersectionnelle à cela aussi, puisqu'on a l'impression que ce sont peut-être les personnes féminines qui occupent des fonctions publiques qui sont peut-être victimes le plus souvent, le plus virulemment des attaques.
Absolument. Factuellement, ça a été démontré que des personnes issues de groupes racisés qui occupent des fonctions publiques, que les femmes, la violence à leur égard est encore plus forte.
Ce fut le professeur Gautreau-Desbiens. I'm looking at the time, and we have one more topic still, the relationship between the Emergencies Act and the Charter. So if someone has literally 2 minutes or less further on freedom of expression, I would be delighted to take it. But we collectively spent longer on peaceful assembly. Freedom of expression, a final intervention?
Obviously, everything was said that needed to be said, clearly.
Okay, thank you very much.
Je vais juste une seconde pour dire, je pense que certainement, ce qui a été soulevé par le professeur Bird rejoint beaucoup ce que le professeur Gautreau-Desbiens dit, dans le sens que la tolérance d'un protêt, est-ce qu'on doit tenir compte du message qui est en train d'être véhiculé par ce protêt-là, et aussi les conséquences, parce qu'on a entendu de la preuve que le message encourageait des menaces beaucoup pour des gens, des femmes et des politiciens. Alors, je pense que ça, c'est une question, certainement. S'il y a d'autres commentaires, ça m'est utile, ou peut-être le faire plus tard, mais est-ce que c'est légitime de tenir compte de ça, parce que l'expression est de la désinformation?
Panelists, is there an answer? Short answer for the commissioner, Professor Gautreau-Desbiens.
Ben, d'abord, comme je l'ai mentionné, dans l'état actuel du droit, la désinformation est permise. C'est protégé constitutionnellement. C'est Zundel qui met en place le cadre juridique. Donc, évidemment, stigmatiser de manière particulière des messages serait en soi une source de contestation constitutionnelle si d'aventure le Parlement décidait d'édicter des lois, par exemple, dans ses champs de compétences en matière de télécommunications, pour davantage resserrer les contraintes dans un sens qui favoriserait une hiérarchisation des informations à partir de faits, pour que les faits objectifs, les faits avérés, démontrés fiablement, ressortent davantage que les fausses nouvelles, la désinformation, bien, évidemment, en soi, ce serait probablement contesté. Ma thèse, c'est qu'à terme, l'approche traditionnelle que les tribunaux ont adoptée un peu partout quant à leur neutralité par rapport au contenu va devoir être mise en cause. On n'en est pas là, mais j'ai l'impression que on s'en va un peu vers là. Et les questions de maintien de l'espace démocratique qui sont au fondement de notre ordre constitutionnel doivent aussi être prises en considération. Il y a une citation que j'aime beaucoup qui est un classique du droit constitutionnel américain, mais c'est le juge Jackson qui disait en 1949 dans l'arrêt Term Yellow, une affaire de liberté d'expression. Il disait, "The choice is not between order and liberty, it is between liberty and order, with order, and anarchy without either. There is a danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact." Et d'une certaine façon, je pense qu'on doit réfléchir au périmètre des garanties constitutionnelles de la Charte canadienne, aussi à la lumière de cette valeur fondamentale qui est la démocratie, qui nourrit, qui irrigue la liberté d'expression, notamment. C'est une des valeurs sous-jacentes. Et puis, on doit, si on regarde dans une perspective institutionnelle le continuum des droits qui sont garantis dans la Charte, il y a aussi un droit qui s'appelle le droit de vote. Des élections au minimum à tous les 5 ans. Et vous posiez la question sur l'occupation tout à l'heure. À un moment donné, quel est le type de message que l'on veut envoyer? Si c'est un changement radical de régime, alors qu'on fasse de la politique.
La Charte canadienne n'a que 40 ans, donc c'est intéressant de constater que déjà, sa jurisprudence peut paraître un peu périmée sur certains points.
It's part of life.
We're turning now, and we have literally 5 minutes. So Professor Bird will share perhaps a comment or two on the relationship between the Emergencies Act and the Charter. Professor Bird.
Thank you, Dean Leckie. So in these comments, I just want to kind of intensify or amplify the radar with respect to how the Charter and the Emergencies Act converse. And so most of the commentary on the federal government's use of the Emergencies Act this year has focused on whether the circumstances in Ottawa last February amounted to a public order emergency. In other words, whether the federal government was legally entitled to invoke the Act. And this is, of course, a very important question for this commission, but it's also not the end of the story. This inquiry is tasked with investigating the circumstances that led to the declaration being issued and the measures taken for dealing with the emergencies. So even if the invocation of the act was lawful, what about the legality of the measures that followed? This question looks beyond the issue of whether the federal government, either at this moment or any other moment in history, can lawfully invoke the act. It certainly engages a downstream issue of whether measures taken after invocation fall within the scope of powers granted by the text of the act. But the legality of these measures also implicates foundational considerations within the Canadian legal landscape. It invites us to think about how the Emergencies Act converses with the Canadian Constitution, and in particular, as we've been discussing today, the Canadian Charter of Rights and Freedoms. And so it could be perhaps tempting to think that the Act, given its substance and purpose and the stakes, transcends or somehow transcends the Charter. Put differently, if the federal government concludes that a given situation satisfies the criteria that permit recourse to the Act, its invocation, some citizens, maybe even the government itself, might slide into thinking that practically anything goes in responding to the emergency and that the Charter need not be consulted. But this way of thinking would be incorrect. The starting point is that every instance of state action in Canada must comply with the Constitution. To the extent that an instance of state action is inconsistent with the Constitution, the action is null and void. And this principle applies with equal force to the Emergencies Act, both in terms of the substance of the Act, its text, and decisions taken by government pursuant to it. The preamble to the Act actually refers to the Charter, noting that the federal government would be subject to the Charter when exercising powers granted by the Act. Now, to be clear, the Charter would still govern the use of the Act, even if the preamble did not mention the Charter. And as for why Parliament included this reference, perhaps it was intended to help us avoid that headspace described earlier, where the Act is somehow perceived as beyond the reach of the Charter. Now, it seems fair to say that in general, the substance of the Act does not unjustifiably limit Charter rights and freedoms. What I mean by that is that legislation that permits the state to take temporary but severe action to deal with extreme situations, insurrections, terrorism, and so forth, will certainly or almost certainly interfere with various charter guarantees like the ones we've been describing or discussing today. Even so, most, if not all of us, can agree that those interferences in those extreme situations would often be justifiable under Section 1 of the Charter. But matters become more complicated once the federal government actually invokes the Act and has recourse to the emergency powers at its disposal. Now, assuming for the moment that the circumstances on the ground satisfy the definition of a national emergency in the Act, it would be incorrect to suggest that each and every use of the powers in the Act that follow invocation will inevitably or automatically comply with the Charter. Even if an emergency as contemplated by the Act exists, each emergency is unique in nature. The federal government must therefore ensure that its use of emergency powers, depending on the features of the emergency at hand, limit charter rights and freedoms in ways that satisfy Section 1.
Thank you. Thank you very much. So we now have a little pause where we look at some questions, and then we'll come back for a final, much shorter session. Thank you very much, panelists.
The commission is in recess for 30 minutes. La commission est levée pour 30 minutes.
we have several questions. We'll begin with the one we wanted to address most importantly, I think. There may be a perception by the police this past winter that the Canadian Charter of Rights and Freedoms, prevented them from, say, stopping the movement of trucks into parts of the city. And so we're curious if there are thoughts on how the Charter, and this is combining, I think, Section 2 and Section 1, so the Charter as a whole. I mean, would police have been able to stop truckers from driving through zones that were zoned as no trucks? Would the Charter have allowed police to stop people parking their trucks? Might the Charter have been satisfied if people were told to, park here and we'll bus you over to a different zone where you could gather?
Right
We're
through trucks.
wondering if you have thoughts on those.
Go ahead.
Professor Moon will start.
Well, I'll attempt that. I mean, I guess I have to preface any answer to that question with really what I think came out in our discussion, and that is people have the right to protest. Protest invariably involves some disruption of ordinary property use, and the question always is, what are the appropriate limits? And it's accepted that municipalities, for example, can put in place different kinds of restrictions, even notice requirements. You're going to have a large protest to inform the police or municipality in advance that you intend to do that. So I think the short answer is, I think they probably could do those things. They could say, no trucks parked in this area, no trucks can enter into this area. But it has to, notionally at least, be justified as a reasonable restriction on the right to protest. And certainly it strikes me, and this is easy to say in hindsight, that it could easily be understood as reasonable, given the amount of space, the pollution, the noise, and so forth that a truck could generate. So again, the real challenge, and I don't envy those who have to make decisions here around any of these questions, is that ultimately it is a very practical determination to decide how much disruption, how long, and so forth. And it would not, to my mind, be unreasonable to say trucks in a space like this is a significant disruption, and the protest can happen, but it's legitimate to exclude trucks from it.
Professor Moon, if I could just follow up. You were talking about reasonable limits and so on, which is evoking the idea of a limit prescribed by law and so on. Do you think like existing no truck zone bylaws or whatever form those rules take, would that have been enough as the legal basis for the police to interfere with what they perceived to be the exercise of the democratic rights?
Without kind of having a sense of what the array of existing rules are that could be drawn upon, I think the answer might be yes, but I don't know enough about what the bylaws would be.
You're hedging your bets a little bit.
I am, absolutely.
Yeah, thank you. Professor Mathen and then Professor Cameron.
So I think it's also fair to look to past practice, and it is true that in the past there were protests and assemblies that did involve trucks, but they did not stay. And that seems to have been part of the landscape in which law enforcement was operating, but there was also information indicating that they intended to stay. And so had they taken that to be a real statement of intent that would pose a different kind of enforcement problem, then I think that would be the basis on which you could absolutely seek to prevent that mode of assembly. Again, it comes down to what does the fundamental freedom actually entail, but certainly given the scale of the vehicles and the information that was widely circulating about what was the intent for those vehicles, at a minimum, yes, you could in that context reasonably restrict them from proceeding in the way that they wanted to the positions where they wanted to place those vehicles.
I'm wondering if Professor Cameron has a different point of view.
I'm not sure what my point of view is, but I would just observe that in Toronto, I believe I'm correct in saying that the trucks were stopped from coming into downtown Toronto. And so the same kind of situation never crystallized in Toronto. As for Ottawa, I would say there's a significant difference between a flow-through demonstration, so where the trucks flow through in a day or 2 days and the trucks stay, as to whether and when they could be stopped. I'm not really sure. I would worry a little bit about prior restraint kinds of concerns. Were all trucks to be stopped and never given any opportunity to come into the capital city and make any kind of demonstration? I would worry a little bit about that, but it's an awkward situation, obviously, because once the trucks are there and they come in, the enforcement issue arises very quickly.
Professor Bird.
Just very quickly, just zooming out a bit, just strikes me that often other protests, thinking of marches where people are walking in the streets, maybe even kind of stopping in a city square or an intersection, oftentimes protests will involve abnormal use of a space. Normally people don't walk down major boulevards in mass, usually it's cars, and usually they'd be on the sidewalks instead. Sometimes that, maybe even some cities, I don't know the array of bylaws, maybe even walking on streets, marching in streets might well also breach bylaws. So just to say that kind of abnormal use of public space for the purpose of protest seems to be quite common, but I agree with all the comments so far as well, very important.
So the factual question of whether there was prior notice of an intention to park might well be very significant as one thinks this through.
So, I mean, just to take this point to the next level, so there seems to be consensus that once trucks are parked illegally and are asked to leave and don't leave, would the assembly then become illegal, or is it an assembly that then is in violation of Section 1? Here they were allowed to park, and then they were asked essentially to leave, and they didn't leave. So that's, I guess, that's the general view.
Well, so much to turn
Professor Moon.
as what the legal authorization would be to remove, and presumably there would be a variety of rules that would permit that, and then the question is whether that would be justified, and I think the consensus would be, particularly in this circumstance, it would be.
Professor Cameron?
Simply to add that on the question of reasonable limits, there are a number of variables. And as for the assembly itself, the general principle is that the assembly needs to be allowed to have an opportunity to present its message. So whatever that reasonable scope of time is, I'm not sure on the facts of this convoy, but then at a certain point in time, it becomes unreasonable for the vehicles to stay. So I think that's a fairly safe assessment.
Thank you, Professor McDonnell.
Just to say that I think this comment about the point, the moment in time, is quite important, because actually the requirements of justification under Section 1 may well be shifting as the situation evolves, right? And so this is my colleagues, Colleen Flood and Brian Thomas, have done some very helpful work on, in an emergency, in a situation like this, what is the court's response, or what's the response, of the state? It has to be connected to what's actually happening, what the facts are. And so that includes, like the situation and what's justifiable in the first 24 hours of the protest will be different than what's justifiable in week 1 and week 2, when you start layering in significant disruption and concerns about, the health and safety of others. Like this shifts the kind of the complexion of the justification analysis. And so actually that element of time is quite crucial and changes sort of what's permissible, right? And that, also changes the state's obligations, I think, right? So at the beginning, there's very little information about a fluid situation. The government has to make a call. They have to act, and they're entitled to act on the best information available to them. And they may not get it perfectly when they're trying to balance the interests of the community. And I think cases like Irwin Toy, which Professor Mathen sort of you adverted to without naming the case, but it's also in Professor Moon's paper. They're very clear that in these complex situations, the government is entitled to act without full knowledge, sort of in good faith. But as time goes on and more information becomes available, then the situation can change. And sometimes the state is under an obligation to kind of adapt its initial assessment of the situation.
The idea of the sort of changing situation, it's very interesting. It takes us a little bit off the initial question of the police, whether they were entitled to sort of stop the trucks before they came in. Commissioner, have you heard enough about the trucks?
No, I'll hear more about trucks over time.
We had another sort of specific question about the charter and what it requires of us. So the emergency measures regulations included a prohibition, as you'll know, on public assembly. A person must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace by the support of the threat or use of acts of serious violence against persons or property. And it also said that a person must not travel to or within an area where such an assembly is taking place. So persons prohibited from entering the area where an assembly might, reasonably be expected to lead to a breach of the peace. Are there views over whether these rules in the regulations would appear to be, reasonable limits on charter rights? Professor McDonnell?
I mean, I'd be very curious to hear the thoughts of others, but it strikes me, at first blush that type of provision might well be might be overbroad, right? And so Section 7 of the Charter provides that individuals have a right to life, liberty, and security of the person, and a right not to be deprived thereof, except in accordance with the principles of fundamental justice. Now, to the extent that those provisions prohibit individuals from being in an area at all, they may, one of the principles of fundamental justice is that laws may not be overbroad, right? They shouldn't capture more people than the objectives of the provision are aimed at. And so it may well be that that's the kind of provision, that provision wasn't sort of sufficiently tailored. That's a possibility.
Thank you. We've got Professor Mathen and then Professor Cameron and Professor Bird.
So I think in considering this question, which on its face, it does look to be overbroad, it is important to consider the very definite time limits in which the Emergencies Act operates, which is essential to its core feature. And that will factor into whether in the circumstance that kind of prohibition is in fact overbroad. I would also point out that with respect to the prohibition on travel, I believe it was accompanied by a series of exceptions.
Okay.
That
Exemptions, yes.
And were those criminal?
Exempt.
Were those criminal prohibitions?
Professor Mathen, just a second.
The exceptions? you're done looking at?
There's exceptions, and we're asking whether those are criminal.
Yeah, they're offenses.
They're offenses under Section 10 of the regulation. Professor Mathen, did we cut you off? Did you finish?
No, I just wanted to say that there was some tailoring of the specific travel, the precise mobility restriction was also accompanied by exceptions. It doesn't obviate the fact that some people would have been prevented from travel, and that was indeed the very intention of the regulation.
Thank you. Professor Cameron?
Thank you. Just a discrete point, which has to do with the designation of protected places and the potential over-designation of protected places, in particular Section 6F that allows any other place to be designated as a protected place by the Minister of Public Safety and Emergency Preparedness. I just have some concerns about that provision and its consequences for public assembly and other charter rights, including freedom of association, those who might wish to associate with a valid, viable assembly. Thank you.
Thank you. Professor Bird?
I was just going to say that, thank you, that the constitutionality of those regulations might also be informed by just the nature of the emergency. That it could be overbroad for the reasons stated by my colleagues on its face, but given the nature of the particular emergency in which they're being applied, it may not be, just depending on the actual application, of just what's on the ground. And so maybe on its face, potentially some overbreadth issues, but depending on the nature of the emergency, it may end up not being perhaps an overbreadth issue at the end of the day once it's actually applied. Just a thought there.
Professor Bird, do you want to explain a little more? I mean, if someone were to bring a constitutional challenge to the enactment, they'd be challenging the written down rule.
Sure, no, absolutely. Thank you for that. I think that it may well be that a part of the analysis might be that given the nature of what's at stake in a potential invocation of the Emergencies Act, what the Act is meant to deal with, assuming that there has been a lawful invocation, public order emergency, public welfare emergency, et cetera, that might well inform whether the regulations that have been put to us are overbroad as well. So it's just the fact that we're dealing with an emergencies legislation, I think it also needs to be brought into the picture as to whether that overbreadth actually pans out. But I do also share the concerns of my colleagues that needs to be brought into the conversation too.
Thank you.
You can move on if you'd prefer.
Professor Moon, were you wanting to jump in?
I really just wanted to first reiterate what Professor Mathen said. Sorry, I keep saying it. And that obviously the temporary nature of it makes a difference. And secondly, I imagine a certain degree of deference is going to be given in a situation where rapid action is understood to be necessary. And obviously when we call it emergency response, then we would understand rapid action to be necessary. So it is obviously on the face very broad and would just in isolation be troubling. But I think those factors certainly would have to be taken into account.
Thank you. Okay, so we're going to move on. Is that okay to the next question?
Yeah, I guess we can. I guess one of the questions is, and maybe that's the overbroad that you commented on, but who makes the determination that it might lead to serious interference, et cetera? And because that's the, it's not clear to me, but that may be the answer, as Professor Bird said, that it's by its nature, because it's temporary and it has to be broad.
But there's a potential rule of law issue in the sense that there's a rule: you must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace. How do you know when a particular assembly has met that threshold such that you're prohibited from going there? There are real questions about that.
Yeah.
Professor McDonnell?
I don't want to drag on the discussion, but there are actually just two very small points that I think are relevant to this overall discussion. One is that violations of Section 7 are very rarely saved under Section 1 of the Charter. So once established, they're very rarely found to be justified. But to the extent that the courts have suggested that there's an opening for finding Section 7 violations to be justified, it's in an emergency situation. And so, one of the things to recognize might be that we may acknowledge that on the face these laws were overbroad, but this very important context that my colleagues have been speaking about is relevant under Section 1 in terms of understanding whether, a degree of overbreadth, which would normally not be permissible, might in a specific context where a declaration of emergency has been made in a time-limited way be found to be justified. And so that, I think, is important. The other quick thing, though, that is maybe in tension with this is, as my colleague Professor Bird pointed out, the Emergencies Act is pretty clear that the Charter continues to apply. And so there is a bit of a tension. All Charter analysis is contextual, does take its color from the circumstances, and here the emergency is part of the circumstances. But to my mind, that type of argument also has its limits because the Emergencies Act specifically keeps the Charter in play. And in fact, the model of emergency control that we have adopted incorporates the Charter as an important safeguard. And so to me, that means, I'm glad I'm not the one making the decision, because there's a tension in there.
Well, and that's why I raise it, is at the end of the day, when much of the concern is that the act is so broad and powerful, but on the other hand, it is charter compliant by its very nature. So the answer to questions such as this one are important because it arguably affects the initial decision because the degree of, or you could argue certainly that the degree of interference with the charter should be taken into account in the initial determination of what the threshold for an emergency is. And
Yes.
I don't think they're detached, but I'm not sure. And that's why I'm curious about the response from you.
Other thoughts on this one? Professor Mathen?
Just because the question was raised, who's the decider, I just want to point out the interesting separation of powers issues that arises here, because initially you have an executive branch determination, but it is in very short order subject to legislative oversight and the opportunity in various ways to contest that. And so again, referring to what Professor Moon said, the zone for deference here to the decision being made in extremis, literally, is something that I think could be useful to consider.
Thank you. So we'll take a crack at another question. And counter-protests are in the question here. So we're wondering, you've got someone protesting or an assembly is protesting, and then there's the prospect of a counter-protest that could bring violent confrontation. And so we're wondering, does the kind of realistic prospect of a counter-protest that will perhaps issue in violence, does that make the initial protest violent or, attach a threat of violence to it? Professor Cameron?
Thank you. In researching the paper, I encountered quite a bit of commentary on just this point in the international jurisprudence and so forth. And basically the position that's taken in that jurisprudence is that the authorities have an obligation and a duty to protect the primary assembly in those circumstances. So that where a counter-protest presents itself and poses risks to the viability and the safety of the principal assembly, it's the duty of authorities to deal with the counter-protest and protect the assembly, which is an interesting point of view. We don't have much guidance in Canada, but that's what I found when I was researching the paper.
Thank you very much. Other colleagues on that one? Professor
It's hard.
Gaudreau-Desbiens?
Oh, sorry.
Oh, no, well, I think that this position is quite sensible and reasonable, actually. The duty that is imposed upon the state to protect the First Assembly, while not prohibiting counter-protesters to express themselves. So you can imagine a situation where police officers create a kind of corridor between the two, but it's a rather onerous burden. But still, both must have the ability to express their views while taking into consideration this duty to protect the First Assembly.
And perhaps Professor Cameron, I mean, so I hear you saying what you're saying in the literature. If the initial protest is seriously harming or threatening the livelihood of the potential counter-protests, does that in any way change their position?
Well, if there are difficulties with, we'll call it the primary assembly, then those can, if that's what you mean, then those can, of course, be addressed.
I mean, the primary assembly is blocking a bridge that is shutting down the workplaces of the potential counter-protests, so like they're not just people expressing a different point of view. Does that change it?
Sorry, they both might be subject to regulation, so we wouldn't rule out the prospect of reasonable limits on the primary assembly, but the counter protest would still be subject to limits in so far as it is confronting and escalating the situation with the primary assembly. That would be my view.
Commissioner, anything?
No, I think to put it a little more directly in context, it's suggested, for example, in Windsor that the road should be opened up and people's livelihoods was affected by the road being closed. And let's assume the counter-protest wanted to open the road. To put it more concretely, and so they would be, in that case, the police would be preventing people from carrying out their legal right to proceed through the road, for example. Gets a little more complicated, I think.
It's not, yeah, that's not exactly
Moon.
counter-protest, I guess, in the sense it's an attempt to exercise what are considered to be the right to move and drive. Because certainly the starting point is everybody has the right to protest or counter-protest and so forth. And then the challenge always is, if it looks like there'll be conflict, to what extent can the police manage that? And only in exceptional situations where it's just unmanageable, given their resources, could it be shut down? But the starting point always has to be both sides. But that's an interesting and challenging question about my right to exercise my ordinary mobility that is directly coming in conflict with what the protesters are attempting to do.
Thank you. We're out of time, so we're going to stop without moving on to the fascinating question of separating the acts of individuals from the Assembly as a whole, which we might otherwise have come back to. Thank you very, very much for your contributions.
Thank you. It's always fascinating to debate these subjects, and it's very useful for me to listen to the submissions and to hear what the questions of participants are. Thank you.
Thank you.
The commission is in recess until 2 o'clock. La commission est levée jusqu'à 14 heures.
Tu parles dans ton micro. Oh, OK, alors.
Thank you.
I'll keep an eye out. I could always also additionally send him an invite. That would be, just grab his email.
Only the
That
end.
happens.
So if you held a stem, you were probably safe.
I got, all I had, my only interactions with him were over email. And the last email I got from him was when he sent the outline. And then on Saturday, I sent the order of speakers, but I just assumed that. I actually thought he was going to be here first.
So I've already, I've resent them the login information. So it's just we don't want to shortchange you, so we may get started. So you may just get started. So lose your time. Well, appreciate it. Oh, I just asked it for 5 minutes.
He's joining, Dan. Admitted him. Heather Patterson includes a poet. You went with the name from somewhere.
The commission is reconvened. La commission reprend.
Alors, vous êtes en charge.
Merci.
Allez-y.
Merci, commissaire. Alors, bonjour à toutes et à tous. Je m'appelle Patrick Leblond. Je suis le modérateur de cette séance. So I'll be moderating this session on financial governance, policing, and intelligence. In terms of, I'm not sure how to best translate, but gouvernance financière, maintien de l'ordre des renseignements financiers. We're very privileged today to have 5 experts, 4 in person, 1 person online. Premièrement, j'aimerais introduire Michel Coumine, qui est professeur titulaire à la faculté de droit de l'Université Laval. Next, we have Jessica Davis, who is president and principal consultant at Insight Threat Intelligence. She is also the president of the Canadian Association for Intelligence and Security Studies. Then Michel Galland, who is professor at the Faculty of Law at the University of Manitoba. Then we have Gerard Kennedy, who is an assistant professor also at the Faculty of Law at the University of Manitoba. And finally, Christian Leuprecht, who is the class of 1965 Distinguished Professor at the Royal Military College of Canada. He is also the director of the Institute of Intergovernmental Relations in the School of Policy Studies at Queen's University, and he joins us online from Germany, if I'm correct. So, la façon que ça va fonctionner, les panélistes, expertes vont faire une présentation d'un maximum de 15 minutes. Ensuite, il va y avoir une discussion que je vais modérer, des questions. Et après la pause, on va avoir une autre série de questions et de réponses. So, I would like to start with, in terms of the order, Christian. Are you ready to go?
Merci de l'introduction. Vous m'entendez bien?
Très bien, merci.
Merci. Je vais intervenir en anglais, mais je prends vos questions dans les 2 langues officielles. So a team that I led supported the Collin Commission with a submission that figured prominently in the final report released in June 2022. And invoking the EA is symptomatic of deficiencies and shortcomings reported by the Collin Commission. I also published a recent book on intelligence as democratic statecraft across the 5 Eyes countries that includes substantial information on financial intelligence, and I have a forthcoming book on financial crime in Canada. So let's look at the typology here. This was not money laundering or tax evasion. The phenomenon that we have is probably closest to terrorist financing. There was an immediate use value to funds provided. The purpose for which those funds were provided was ambiguous. It wasn't clear whether they were being withdrawn for legal or illegal purposes. Small donations can have a relatively large impact, and in this case can also serve as a proxy for the extent of public support. So let's think about this. A G7 country with the world's 10th largest economy had to invoke the EA in part to get a handle on some crowdfunding that was in part sustaining some illegal activity. What does this tell us about the adequacy, effectiveness, and efficiency of Canada's financial regime? Within Canada, money laundering is currently governed by 15 different laws and regulatory instruments. At the federal level, Canada currently has 12 agencies tasked with AML enforcement and prosecution, while there are approximately 14 within each province. In February, this sizable financial crime policing apparatus was unable to achieve the necessary strategic effect without the EA. That casts a long shadow over the purported efficacy of laws, regulations, and agencies. And although Canada's system appears quite robust, it is actually very weak. So weak, in fact, that Transparency International has ranked Canada at the bottom of G20 countries. What are the implications? First, the inadequacy of legislation, regulations, and agencies. Key allies can achieve the same strategic effect without invoking emergency measures, because their legislation, regulations, and agencies are actually up to date and properly postured and funded. Second implication, the inadequacy of the posture of Canadian agencies. Expert federal agencies and their financial reporting entities couldn't get it done under existing rule of law powers. Third implication, at least a perception, if not a reality, of the unequal, inequitable, idiosyncratic application of the rule of law. That is, crowdfunding played a role in blockades of critical infrastructure and other environmental protests, for instance, that crossed into the line into civil disobedience, illegality, perhaps criminality, including disregard for court injunctions. But no extraordinary measures were taken to stem financial flows to these groups. So the impression, when the government is sympathetic to protesters and their cause, it goes easy on them. When the government is not, it will go to extraordinary lengths to shut them down. That impression, if not the reality, undermines the very premise of constitutional democracy, that the rule of law applies equally to all citizens, to thwart precisely what we're witnessing here, the tyranny of the majority. Fourth implication, in February, the Prime Minister wanted foreign money funding illegal protests in Canada to stop. Minister Mendocinos remarked about the number of contributions and their sheer size. But CSIS testified before this very inquiry that it found no foreign actors funding the protest and told the government that back in February. So, did the government engage in deliberate misinformation on foreign funding anyway? Implication 5. Compare the Prime Minister's preoccupation with foreign funding of a relatively small but tenacious protest in Ottawa with his government's inaction on Chinese foreign influence in Canadian elections and democratic institutions, Chinese police stations in Canada, and sanctions on Russia. Words in Canada speak louder than action. In the UK, 19 billion pounds in assets have been frozen. In Belgium, 52 billion euros. In Canada, 122 million Canadian dollars. It would appear that dirty Russian money in Canada is not a priority. But 20 million raised over 3 weeks entirely from Canadian sources for protest by Canadians warrants invoking the EA? There are two ways to read this. The threats to Canadian democracy are as real from within as they are from without, or that it's okay for US, Chinese, and Russian money to interfere with Canada's democratic processes and interests, just not for Canadians with Canadian money, especially if they're opposed to the federal government or its policies. 6 implications. Donors came from across Canadian society, including prairie farmers. They've now seen how the government is prepared to go after people and their assets should they fund a social movement that is opposed to the current government or its policies. The unintended consequence? They've restructured their assets to put them out of reach for government and moved support for controversial social movements online onto cryptocurrency, which makes these financial flows less visible and harder to track. So the EA has had perverse incentives of making work much more difficult for intelligence agencies. The conclusion, was it really worth to invoke the EA? So how did we get here, and what does it tell us? First, financial intelligence in this country is embarrassingly weak. FinTrack is an outlier among FIUs. It's an administrative FIU. It does not have investigative capacity, the right to request directly from the reporting entities any additional financial information, and a right to freeze suspicious transactions. FinTrack is a passive type of FIU because it mostly produces reactive disclosures that are linked to voluntary information records submitted by law enforcement. Canada has an exceptional defensive reporting regime that at $6.8 billion a year is very expensive for banks. Justice Cowan concludes, law enforcement bodies in this province cannot count on FinTrack to produce timely, actionable intelligence. Second, weak criminal intelligence and the inadequate posture of enforcement agencies. There is a paucity of investigative and prosecutorial ability. In 2018, for example, the RCMP publicly confessed that it had no expertise to conduct sophisticated financial or corporate investigations. Canadian data show that 86% of money laundering charges filed between 2012 and 2017 never made it to trial because they were withdrawn or stayed. There are sensational recent examples in both Toronto and Vancouver to this effect. And in 2020, the RCMP disbanded its financial crimes unit in Ontario altogether because priorities shifted. Third, weak legislation. Just one example. At least since 2002, FATF has recommended that governments pass laws to ensure that lawyers collect, maintain, and disclose information concerning client billings to government regulators. The step is thought to be necessary to guard against the use of lawyers as willing or unwilling dupes who are being paid with crooked dollars. In peer reviews, FATF has highlighted the ongoing non-compliance by 2 countries that refuse to abide by the disclosure recommendation: Canada and the United States. Fourth, weak penalties. For instance, KPMG, one of the world's big 4 accounting firms, had set up an aggressive tax plan that they marketed to high net worth individuals who lived mainly in British Columbia. In March 2016, the CBC published reports that indicated the CRA had entered into overly generous settlement agreements with taxpayers. One unhappy taxpayer went to the media with their complaints. But part of the controversy surrounded the fact that no sanctions were ever levied against the tax advisors, the accountants, and the lawyers who set up and then marketed the plan in the first place. What does this tell us? That Canadian national security, including financial intelligence, is not fit for purpose for the 21st century. What's the government's response? It announces seemingly ambitious but essentially unquantifiable and vague policy to root out corruption, increase regulatory oversight, tackle the opioid crisis, make housing more affordable for ordinary Canadians. Compare that to the government's determined commitment and response to counterterrorism. By contrast, the EA and Cullen are a measure of the government's inattention to financial crime. How then to explain the disconnect between the Canadian state's avert commitments and its failure to deliver on such commitments? Because there is no political or corporate will. The message is, don't ask, don't tell. Especially the Panama Papers and the Paradise Papers findings, as well as the 2020 Tax Justice Network figures, suggest that Canada is not unduly worried about the cleanliness of financial flows, whether from immigration or from investment. There's a mix of activities that are illicit, for example, capital flight and business investment, illicit, for example, white-collar crime and tax evasion, and on the fringes of legality, for instance, aggressive tax avoidance and trade-related malpractices. Having spent decades building a reputation as a haven and global shelter for illicit gains, the government does not have the intent to slaughter its golden goose. Invoking the EA sends a clear message. This is a one-off measure to contain a controversial social movement that is causing the federal government at the time political headaches. Purveyors of dirty foreign money and their enablers need not worry, because Canada isn't about to change its regime or its mantra. Canada is still open for dirty money. The Crown Commission confirmed what we all already knew, that the Canadian financial regime works very well for criminals and the ultra-rich, to the detriment of the middle class and everyone else. The message in invoking the EA: if you're a criminal or ultra-rich, you need not worry. In short, the justification for invoking the EA: that instead of building a financial regime that's actually fit for purpose for the 21st century, temporarily invoking the EA was far more expedient. Merci.
Merci beaucoup, Christian. So actually, you were within time. Excellent. Now I would ask Jessica Davis, please. 15 minutes.
I'd like to begin by thanking the Commission for inviting me to be part of this roundtable. I believe that this inquiry has a critical role to play in making Canada safer and more just. Today, I'd like to share 4 main points with you. I want to first address the issue of foreign funding of the convoy and why that was so contentious for Canadians. I will then discuss the issue regarding regulating crowdfunding platforms and some of the costs and benefits of this approach. Third, I want to raise the issue of unintended consequences of the global anti-money laundering counter-terrorist financing regime and Canada's role in that. And then finally, I'll discuss the role of asset seizure in response to a protest. I'll conclude with a brief set of recommendations. Before I get too far into this, though, I do want to emphasize one point. During my comments, I'll be talking about money laundering and terrorist financing. This is the context of Canada's anti-money laundering counter-terrorist financing regime and changes to FINTRAC's legislation and regulations. I want to be clear, though, that the convoy protest financing falls outside of definitions of both money laundering and terrorist financing, which is part of why some of these amendments were made. So let's talk about foreign funding of the convoy. As we saw from this Commission's work, the majority of the convoy was not foreign funded. There were some foreign donations, particularly to the crowdfunding campaigns, but the majority of the money distributed to the convoy protesters came from Canada, either from the online campaigns or through email money transfers or through cash donations. The uproar around potential foreign funding began early, as soon as people began to see other people who self-identified as from outside Canada donating on those public platforms. These donations raised the issue of potential foreign influence, both overt and covert, relating both to the funding of the protests as well as potential artificial amplification of convoy-related messaging on social platforms. Many Canadians expressed surprise that this was permitted under Canadian law. The strong reaction from Canadians about foreign funding of the protest, real or imagined, is an opportunity for Canada. It tells us that Canadians are concerned about this, and that for many, the idea of foreign countries or foreign individuals being able to contribute funds to political causes in Canada is unacceptable. We should take this as an opportunity to scope and legislate limits to foreign funding in Canada, including potentially limits on contributions to political causes, limits to donations to politicians, even outside an election cycle, and the creation of a registry of foreign agents. This would go a long way towards assuaging the concerns of Canadians about foreign entities, clandestinely, deceptively, or even overtly seeking to influence Canadian politics. I now want to briefly touch on the issue of crowdfunding campaigns and their regulations. The inclusion of crowdfunding platforms as reporting entities under the Proceeds of Crime, Money Laundering, Terrorist Financing Act was a somewhat curious response to the convoy. It was curious for a number of reasons. Because one of the platforms had already taken action to remove one of the main campaigns due to potential breaches of service, terms of service rather, because many of the funds were already frozen, because much of the funding of the convoy wasn't even happening through those crowdfunding campaigns, but rather through those email money transfers and cash donations, as well as payments for expenses like hotel rooms from individuals not present in Ottawa. And finally, because the decision was also made to freeze those individual accounts at the same time. It remains unclear what the regulations were meant to do or how they helped bring about an end to the convoy protest. The regulation of crowdfunding campaign platforms created new reporting entities for FINTRAC. But I question whether it actually created a new source of financial intelligence that could be used to counter the protest or other potential threats to the security of Canada. Prior to the Emergencies Act, for example, some of the funds from the crowdfunding platforms would already have been reported to FINTRAC by entities already regulated under the Act, like banks, when those transactions reached reporting thresholds. Aside from those mandatory reporting thresholds, most of which have already been covered prior to the emergency measures, the new regulation of crowdfunding platforms requires these platforms to now file suspicious transaction reports. But in the context of a crowdfunding campaign, I struggle to see how these entities will report suspicious transactions, particularly when that reporting is limited to suspected money laundering or terrorist financing, As an aside, crowdfunding platforms are not widely used for either of these types of financial crimes. Instead, when we see crowdfunding platforms being used for this, or crowdfunding rather, it's primarily off-platform campaigns. So basically social media calls that are more widely used, which of course falls outside the scope of the regulations. And back to the issue of creating new reporting entities for FINTRAC, this means that FINTRAC now needs to ensure that they comply. Adding more reporting entities without significantly enhancing FINTRAC's ability to conduct compliance exams, for example, is a missed opportunity. Last year, the Centre completed 151 compliance exams, but there are tens of thousands, I believe 24,000 reporting entities. So this regulation might not have achieved much, further stretched FINTRAC's compliance function, and contributed to over and duplicative reporting to FINTRAC. And there's little point in creating more regulations without simultaneously enhancing FINTRAC's ability to ensure compliance. I'll move on to my third point, which is a little bit more about the unintended consequences and global implications of this. The international regulation of crowdfunding platforms. So since the convoy, there have been other calls for global standards to regulate these platforms as part of the global counter-terrorist anti-money laundering efforts. But these, again, are not based in much evidence of use of these platforms for illicit purposes, but instead represent something like more low-hanging regulatory fruit. At a recent No Money for Terror ministerial conference, the host country, India, called for further regulation of the sector, something that Canada is now leading the way on internationally, for better or for worse. As countries and multilateral bodies continue to regulate more and more sectors under these global anti-money laundering counter-terrorist financing rules, it's important to keep in mind that there are plenty of unintended consequences of these efforts. For instance, authoritarian regimes often use these laws and regulations adopted to conform to these global norms to crack down on dissidents in their own countries. As my colleagues from the Royal United Services Institute recently noted, these laws are used for a number of things, including politically motivated pretrial detention, targeted audits, and asset freezes. Canada is now leading the way on regulating crowdfunding platforms, something that can easily be misused by authoritarian states, all under the guise of compliance with international norms. And that regulation has been adopted without consultation, public analysis of costs and benefits, or even an articulation of what it's meant to achieve. I'll move on now to the role of asset freezing, seizures as a response to the protest. This is probably the most contentious element of the emergency measures because it directly targeted Canadians and their financial well-being without judicial authorization. The freezing of accounts and financial assets in Canada is usually done with judicial authorization. This is no small measure.
Slow her down.
When accounts are frozen, there are serious efforts not only for individuals directly targeted by the asset freezes, but their family, employees, and business associates. There are serious implications for individuals who might not be able to pay mortgages, child support, rent, groceries, etc. At the same time, when these measures are used in a targeted manner, they can be highly effective at encouraging people to cease and desist illegal activity and can facilitate a peaceful resolution. However, the way these emergency measures were implemented raises a number of issues. The main issue was in the identification of individuals whose accounts should be frozen. While the RCMP provided a list of influencers to financial institutions were also enabled to use their own internal processes to identify individuals whose accounts should be frozen. When such extraordinary powers are used, there should be a clear list of individuals to whom these measures apply. Deputizing banks to make their own determinations about freezing of accounts created the possibility of mistakes, uneven application of measures between banks, and allowed the spreading of misinformation that further fueled anti-government sentiment. The emergency financial measures served as a lightning rod for the convoy protesters, enhancing their distrust in government and lacked sufficient guidance, oversight, and transparency. While the measures might have been a justified and proportional response to the Ottawa occupation and border blockade, something for this commission to consider, their implementation raises serious concerns. Let me now conclude by summarizing the recommendations that I've mentioned in this commentary. So there are a number of issues that I've raised here today that require legislative, regulatory, or other policy responses to make Canada safer and more just. So I recommend that we limit foreign funding of political activities in Canada, both overt and covert, through legislation, including a registry of foreign agents. I further recommend that the Government of Canada undertake consultations on crowdfunding regulations and any future expansion of the Proceeds of Crime, Money Laundering, Terrorist Financing Act, specifically with an eye towards unintended consequences and setting of international norms. These are powerful tools that are easily misused in the wrong hands. Canada should also enhance its ability to examine the compliance of reporting entities under the regime. Our compliance regime is already stretched, and adding more reporting entities does not improve this situation. And finally, any future use of the Emergencies Act and financial measures should include provisions to clearly specify the scope of financial targeting, enhancing transparency around that financial targeting and reporting, and direct financial institutions in a more concrete way. Such sweeping financial powers should not be left to individual financial institutions' judgment. Thank you very much for your time today, and I'm pleased to answer any questions you have or expand on any of the points I've made.
Merci beaucoup, Jessica. Alors, on va poursuivre. Maintenant, je demanderai à Michel Comines. S'il vous plaît, Michel.
Oui, merci, professeur Leblond. Alors, je m'appelle Michel Comines. Mon expertise porte principalement sur les règles du droit privé applicables au sociofinancement. Et de façon plus accessoire, je m'intéresse aussi à la gouvernance des plateformes en ligne qui offrent des services de sociofinancement. Mon intervention portera sur les trois éléments suivants qui sont tirés du rapport d'experts que j'ai préparé à la demande de la Commission sur l'état d'urgence et qui est publié dans son site Web. Premièrement, le droit privé applicable au sociofinancement sous forme de dons. Deuxièmement, le caractère politique et parfois subversif de certaines campagnes de sociofinancement. Et troisièmement, la portée des nouvelles mesures qui visent à assujettir les plateformes de sociofinancement aux dispositifs découlant de la loi sur le recyclage des produits de la criminalité et le financement des activités terroristes. Alors, premier élément, le droit privé applicable au sociofinancement sous forme de dons. Le sociofinancement sous forme de dons fait naître des rapports juridiques entre trois acteurs ou trois catégories d'acteurs. D'abord, le porteur de projet qui lance la campagne de sociofinancement et qui souvent administre les dons. Ensuite, les donateurs qui contribuent à la campagne de sociofinancement. Et enfin, les bénéficiaires à qui sont destinés les dons. Le porteur de projet peut être une personne physique, une personne morale ou un groupement informel qui souvent n'a pas même d'existence juridique. Par exemple, je pourrais former un groupe qui s'appelle Liberté 2022 et lancer une campagne de sociofinancement en indiquant Liberté 2022 comme porteur de projet. Quant aux bénéficiaires de la campagne, il peut s'agir de personnes nommément désignées ou il peut s'agir d'un groupe de personnes plus ou moins bien définies, ou enfin, il peut s'agir d'un projet ou d'une cause. Par exemple, le groupe Liberté 2022, porteur de projet, pourrait lancer une campagne qui a pour objet de payer les dépenses de Luc Tremblay, arrêté pendant le convoi de camionneurs. Dans ce cas, le bénéficiaire est une personne nommément désignée. Ou alors, le groupe Liberté 2022 lance une campagne ayant pour objet de soutenir financièrement tous les camionneurs qui ont participé au convoi. Les bénéficiaires font alors partie d'un groupe plus ou moins bien défini. Et enfin, troisième possibilité, Liberté 2022 pourrait lancer une campagne de sociofinancement ayant pour objet de soutenir la création d'un film pour raconter le convoi, auquel cas il s'agit de financer un projet. À ces trois catégories d'acteurs, donc le porteur de projet, les donateurs et les bénéficiaires, il faut ajouter la plateforme en ligne qui offre des services de sociofinancement, par exemple GoFundMe ou Give-Send-Go, deux plateformes qui ont été impliquées pendant le convoi. Ces plateformes publient les modalités de la campagne de sociofinancement sur une page dédiée de leur site et acheminent les dons des donateurs aux porteurs de projet ou aux bénéficiaires. Pour prélever les dons et les transférer, les plateformes de sociofinancement ont recours à des entreprises de services monétaires telles que PayPal, Apple Pay, Google Pay et ainsi de suite. Le cadre juridique applicable au sociofinancement sous forme de dons est mal défini dans le droit privé des différentes provinces et territoires du Canada. Le droit privé doit permettre de déterminer qui est propriétaire des dons et qui a le contrôle sur les dons et à quel titre. En droit québécois, on se demande qui est donataire. Est-ce que c'est le porteur de projet ou est-ce que ce sont les bénéficiaires? S'il s'agit du porteur de projet, cela implique qu'il en est pleinement propriétaire et qu'il peut en disposer à sa guise. Les donateurs et les bénéficiaires auraient alors peu de recours si les dons n'étaient pas utilisés conformément à l'objet de la campagne. Donc, il serait préférable de considérer que ce sont les bénéficiaires qui sont donataires. Après tout, c'est aux bénéficiaires que les dons sont destinés. Cependant, on rencontre alors un problème quant à la validité des donations, toujours selon le droit québécois, parce que pour que les donations soient valides, il faut l'acceptation du donataire et cette acceptation fait souvent défaut, surtout si la campagne a pour objet de soutenir un groupe de bénéficiaires mal défini, un projet ou une cause. Dans le droit des autres provinces et territoires du Canada, la qualification de fiducie, trust, serait probablement retenue. Ainsi, le porteur de projet et toute autre personne qui se charge d'administrer et de distribuer les dons serait considéré comme fiduciaire de ces sommes, trustee. Cette solution apparaît comme la plus souhaitable parce qu'elle impose des devoirs stricts aux porteurs de projet et aux autres personnes qui administrent les dons, afin qu'elles soient tenues d'utiliser les dons pour l'objet de la campagne de sociofinancement. Cependant, l'application du droit des fiducies soulève des difficultés en droit canadien actuel parce qu'il s'agit souvent de fiducies ayant un objet non caritatif, un non-charitable purpose trust. Ainsi, la fiducie risque d'échouer en raison de l'indétermination de son objet. Par ailleurs, le droit actuel ne donne pas de solution adéquate lorsque les dons deviennent impossibles à utiliser pour réaliser l'objet de la campagne ou qu'il subsiste un reliquat de ces dons. C'est pourquoi la Conférence pour l'harmonisation des lois au Canada, the Uniform Law Commission of Canada, a conçu une loi uniforme sur le sociofinancement sous forme de dons qui permet de résoudre ces difficultés. La loi uniforme reconnaît que le sociofinancement sous forme de dons donne naissance à une fiducie et adapte les règles de la fiducie pour mieux régir les rapports entre les parties. L'adoption de la loi uniforme à l'échelle canadienne apportera une meilleure protection aux donateurs et aux bénéficiaires et clarifiera les rapports juridiques à l'égard des dons. À qui appartiennent ces dons et qui peut exercer un contrôle sur eux? Cette question me semble essentielle puisque les tentatives de réglementer le sociofinancement, comme celles dont nous discutons aujourd'hui, peuvent dépendre pour leur mise en œuvre de la question de savoir qui détient les fonds ou les dons et à quel titre. Par ailleurs, un autre avantage de la loi uniforme est qu'elle permettra de baliser les pouvoirs des plateformes de sociofinancement. À l'heure actuelle, les conditions d'utilisation des plateformes leur accordent une très grande discrétion qui leur permet de s'immiscer dans l'administration et la disposition des dons. La loi uniforme prévoit que toute personne agissant de la sorte devient fiduciaire. Ainsi, les devoirs stricts qui incombent aux fiduciaires s'appliqueraient aux plateformes de sociofinancement dès qu'elles interviennent dans l'administration et la disposition des dons. Le deuxième point que je souhaite aborder concerne le caractère politique et subversif de certaines campagnes de sociofinancement sous forme de dons. Certaines campagnes de sociofinancement ont attiré l'attention ces dernières années en raison de leur caractère politique et même subversif. On se rend compte de leur efficacité pour mobiliser et financer des mouvements citoyens et parfois des mouvements de contestation qui ébranlent l'État. On a vu le sociofinancement jouer ce rôle lors du mouvement de protestation de 2019 à Hong Kong. Les manifestants ont su tirer profit des attributs suivants qui caractérisent le sociofinancement: sa simplicité, sa spontanéité, son informalité, son caractère mobilisateur, son caractère international et sa capacité de déjouer les autorités. On retrouve ici, me semble-t-il, certains parallèles avec l'utilisation du sociofinancement lors du convoi. La campagne We Fund the Wall est un autre exemple intéressant d'une campagne de sociofinancement au caractère très politique. Cette campagne, qui a permis d'amasser plus de 25 millions de dollars par l'entremise de la plateforme GoFundMe, avait pour objet la construction d'une partie du mur que le président Donald Trump avait promis d'ériger sur la frontière entre les États-Unis et le Mexique. Après le début de la campagne et probablement à la demande de GoFundMe, le porteur de projet a constitué une OBNL, une organisation à but non lucratif, pour recueillir les dons. Cela n'a pas empêché plusieurs individus, dont Steve Bannon, de divertir une partie des dons à leur profit. Et ces personnes font l'objet actuellement d'accusations criminelles pour fraude. Plusieurs campagnes de sociofinancement politiquement chargées ont provoqué des scandales, incitant certaines plateformes à s'en distancier et d'autres à les accueillir. Cela peut conduire à la politisation des plateformes elles-mêmes. Je crois qu'il faut garder à l'œil ces phénomènes et s'assurer que les lois électorales sur le financement des partis politiques permettent un encadrement adéquat à l'égard de ces phénomènes. Cependant, du fait même que le sociofinancement revêt parfois un caractère politique, il faut aussi s'assurer que la liberté d'expression et d'association ne soit pas brimée par les contrôles dont il fait l'objet. Par ailleurs, les quelques campagnes fortement médiatisées qui ont une dimension très politique ne doivent pas nous faire oublier que la vaste majorité des campagnes de sociofinancement sont fondées sur l'entraide et la volonté de mener à bien des projets qui sont bénéfiques pour la collectivité. Ce serait dommage qu'en imposant au sociofinancement un cadre trop rigide ou trop lourd, on décourage ces initiatives dont les retombées sont le plus souvent positives. Et le troisième point que je vais aborder très brièvement concerne la portée des modifications au règlement sur le recyclage des produits de la criminalité et le financement des activités terroristes, adopté le 5 avril 2022 pour assujettir les plateformes de sociofinancement sous forme de dons au règlement. Et ici, mon propos va rejoindre dans une grande mesure celui de Jessica Davis, avec qui je suis largement en accord. Alors, cette modification peut être vue comme la continuation des mesures financières découlant du décret sur les mesures économiques d'urgence. Les plateformes de sociofinancement sont désormais considérées comme des entreprises de services monétaires ou des entreprises de services monétaires étrangères. Par conséquent, elles sont assujetties à de nouvelles obligations auprès de CANAF, à savoir notamment remplir les exigences relatives au besoin de bien connaître son client, y compris de vérifier l'identité des personnes et des entités pour certaines activités et opérations, conserver certains documents, dont ceux concernant les opérations et la vérification de l'identité des clients, et déclarer certaines opérations à CANAF. Comme plusieurs l'ont souligné, il y aurait lieu d'examiner l'utilité de ces mesures, puisque les plateformes confient généralement le traitement, ou peut-être même toujours, en fait, dans tous les cas que je connais, ils les confient, le traitement des paiements à des intermédiaires qui sont déjà visés par le règlement. Alors, dans ces observations, en réponse à mon rapport d'expert, le ministère de la Justice du Canada souligne que la plateforme de sociofinancement possède des informations ou peut mettre en œuvre des mécanismes pour recueillir des informations que ne détiennent pas les entreprises de services monétaires. Je trouverais utile d'en savoir davantage sur la nature de ces informations additionnelles que seules les plateformes de sociofinancement sont susceptibles de détenir. Et je souhaiterais aussi savoir pourquoi ces informations additionnelles sont nécessaires ou utiles pour la réalisation de l'objet de la loi. Par ailleurs, je voudrais souligner que plusieurs personnes ou groupes recourent au sociofinancement en créant une page de dons à même leur site Web. Ces personnes ou groupes n'utilisent pas les services d'une plateforme de sociofinancement, mais elles utilisent les services d'une entreprise de services monétaires. Alors, selon ma compréhension, de telles campagnes de sociofinancement échapperaient donc aux nouvelles mesures mises en place pour mieux surveiller les activités de sociofinancement. Les porteurs de projets qui désirent éluder les nouveaux mécanismes de cueillette d'informations que devront mettre en œuvre les plateformes de sociofinancement pourraient donc s'y soustraire en créant une page de dons à même leur propre site Web. Si le but des modifications introduites le 5 avril 2022 est de s'assurer que la plateforme de sociofinancement vérifie l'identité des porteurs de projets ou des donateurs et conserve une trace de leurs activités, cela me préoccupe du point de vue de la protection de la vie privée. Actuellement, les plateformes de sociofinancement recueillent assez peu d'informations de cette nature. Les données que devraient collecter les plateformes à la demande de CANAF sont aussi des données dont elles pourraient faire un usage préjudiciable aux individus concernés. C'est la préoccupation que je voudrais formuler en vous remerciant beaucoup de votre attention.
Merci beaucoup, Michel. So now we'll move to Gerard Kennedy. Please, Gerard, 15 minutes.
Merci beaucoup pour votre invitation. Je m'appelle Gerard Kennedy. Mon expertise en le droit procédural et le droit administratif. And I'm deeply honored to be speaking on the procedural rights that individuals have regarding their property and how the invocation of the Emergencies Act would have affected that. In essence, I'm going to suggest that there were indeed common law procedural rights that individuals have concerning their property that were clearly affected by the events in February. However, because these are common law rights, they can be overridden by regulation or legislation. So insofar as the invocation of the act was lawful, taking away procedural rights that people have before being deprived of property was also lawful. And given that the Canadian Constitution doesn't protect property rights, the Constitution won't change anything in that analysis. The Canadian Bill of Rights might more plausibly have something to say, but it's uncertain. From a policy perspective, the legality of sending these procedural rights into abeyance is probably not desirable. And insofar as this commission has a policy role, I'll make some recommendations. But I don't think that affects the legality of what occurred in February. And insofar as procedural rights cannot be reconciled with the Act's invocation, I would suggest that that's a reason to not give the statutory prerequisites that justify invoking the Act a broad interpretation. In other words, an interpretation more consistent with the preservation of common law rights should be preferred. Starting with a few first principles, individuals have a right to enjoy their property. That's been recognized for centuries. And that can be limited in various ways, but generally speaking, that is adjudicated in the courts, either because there is an action to freeze the property or because individual A has commenced an action against individual B, asserting that their use of the property somehow impinges upon their rights. And in doing so, the rules of procedural fairness and civil procedure have got to be followed. These can look a little different in exigent circumstances, and I'll return to that, but generally that's the case. Moreover, before the executive branch of government deprives one of one's property, it has to follow the rules of natural justice, or to use the modern Canadian parlance, procedural fairness. Been recognized in England for centuries, and certainly applicable in Canada. The content of this procedural fairness will vary according to the circumstances, but generally it's always going to include notice of the proposed seizure or freezing and some sort of opportunity to respond. I'd like to emphasize these are procedural rights to property. Doesn't mean that one's rights to property, that property can't be seized or frozen or forfeited or even destroyed. It does mean, however, that certain procedural hoops need to be jumped through before we go down that route. Moreover, the executive branch has no substantive power to take property unless authorized by a statute. So a statute needs to authorize the taking. So prima facie, without getting into the factual reads, in early February 2022, the members of the convoy had these protections, that processes would be followed before their property rights were taken away. However, the Emergencies Act is a statute that clearly authorizes takings, and the emergency measures regulations and the economic measures orders make it quite clear that the procedural rights as well as the substantive rights were restricted in various ways, as we have already heard from my co-panelists. So to give an obvious example, entities such as banks had to cease making available any property for designated persons, among many other things. It made it very clear that no court order was necessary and the entities were immune from any sort of liability from complying with the regulations, which probably resulted in erring of the sides of more seizures. Now, I will suggest that that does not fulfill the common law purpose of notice to persuade the decision maker that you should not be deprived of your property rights because you should not be a designated person, and there is no centralized authority to making someone a designated person. One could argue that determining individuals to be designated persons is an administrative decision and not a quasi-legislative decision, and that some sort of process should be contemplated there. Possibly, but that isn't spelled out in the orders, and it's also complicated by the fact that these decisions were generally made by non-state actors, which complicates somewhat the applicability of administrative law. I'll come back to this shortly in the policy discussion. Now, we don't live in a country of legislative supremacy entirely. The Constitution constrains government action in various ways, and you heard this morning and here later this week about a lot of other rights that were potentially impacted by the Act's invocation, where the Charter has a lot to say about matters. But property rights aren't in the Constitution. That was a deliberate choice in 1982, and it would be inappropriate to try to give them constitutional status at this stage. It doesn't mean they don't exist, but they're not constitutionalized, not even procedural protections to them, which again makes Canada a bit of an outlier around the world, but it is still very much the case of the Canadian Constitution. The Canadian Bill of Rights, on the other hand, does guarantee procedural rights regarding property. For instance, Section 1A guarantees a right to enjoyment of property and the right not to be deprived thereof except due process of law. This use of due process is fairly rare in Canadian law. It's somewhat of an American import where we've tended to use natural justice or fundamental justice or procedural fairness. But it has significant overlap to principles of procedural fairness. Moreover, Section 2E of the Bill of Rights holds that statutes shall not be construed to deprive a person of the right to a fair hearing in accordance with the principles of fundamental justice for the determination of rights and obligations. Though I'll note that that doesn't guarantee a particular process, but rather interference with processes already authorized at law. So there's nothing problematic from a Bill of Rights perspective with the mere fact that such a process was not prescribed in the orders. Moreover, the procedural protections for property have been interpreted quite narrowly, only to instances where there is discretion to deprive the person of their property. So if legislation takes away the right to property unambiguously, the Bill of Rights protections are inapplicable. Moreover, the specific due process rights protected by the Bill of Rights must have existed in 1960, as the Bill of Rights is a statute to be interpreted the way it would have been after it was passed. So, what does this mean about the Bill of Rights? Well, the enactment of the regulations themselves does not pose a Bill of Rights problem because the Governor and Council enacted them in a quasi-legislative capacity. Having such a hearing before Cabinet clearly seems to have not been a right pre-1960. More plausibly, individual decisions about the particular individuals whose assets would be frozen could attract Bill of Rights due process protections because they are administrative rather than legislative acts. At the same time, while that's a plausible reading of the Bill of Rights, there's relatively little case law on it, despite it being over 60 years old. It's never been interpreted in circumstances such as this. There probably is a pre-1960 right to have notice or a hearing before property is frozen by the executive, but does it apply to the implementation of cabinet decisions? Does it matter that this is an emergency, if not statutorily, at least colloquially? Does it matter that private entities actually did the freezing? Does it matter that it's a very clear regulations? These complicating factors make the way in which the Bill of Rights could affect things somewhat uncertain. So I'm going to transition to my policy points, and in doing so, though, I will discuss what a hearing that preserves a measure of procedural protection, whether at the Bill of Rights or otherwise, could look like. Procedural law recognizes there are exigent circumstances where property has to be frozen soon. So, for instance, Anton Pillar and Moreva orders in the civil litigation process allow searches of property or seizing of assets without notice if there's reason to believe that responding parties will hide assets or something similar. There has to be judicial authorization to be sure, but there are opportunities to challenge after the fact, and there will be significant consequences if a party was not forthcoming regarding how it obtained the order. And there are other circumstances, notably in the Money Laundering and Terrorist Financing Act, that give individuals post hoc ability to challenge asset seizure and get a resolution quickly, addressing the concern already identified that the freezing and lack of access to one's bank accounts can have really profound effects on one individual's lives, while still recognizing there are circumstances where it is absolutely necessary. But that was not, such a process wasn't apparent in the regulations, and I don't think that poses a legal problem, given the broad nature of the act, but I do think it may be a good idea to amend the Emergencies Act to prescribe a process to review the seizure of property analogous to what is seen in the Money Laundering or Terrorist Financing Act, particularly for emergencies that, or states of emergency that last quite some time. Because in this case, it lasted 9 days, but there's nothing inherent that that's necessarily going to be the case. And I'd like to also echo Jessica Davis's view that the designation of individuals should be named, if not by the governor and council, by some sort of designated central authority, both in terms of making it easier to determine the applicability of administrative law principles and to not have this kind of ad hoc situation where what kind of procedure, if any, would be necessary is very uncertain. So far, I've suggested that there are ways that we could improve the Emergencies Act and future orders in council to preserve more of a protection for property rights, recognizing there are exigent circumstances where property rights have to be suspended and traditional civil procedure is not going to work. But in light of that, I would suggest, because of the general principle of statutory interpretation, to read rights-limiting legislation strictly, I'd encourage this commission not to interpret the Emergencies Act broadly, given that it can deprive individuals not just of their substantive rights to property, but also any kind of procedural ability to protect it. It's a well-established principle of statutory interpretation that rights-restricting legislation, including property rights-restricting legislation, is to be interpreted strictly. It's also a principle of statutory interpretation that legislation intends to be consistent with the common law to the extent possible. So in this case, if the commission finds that it's a gray zone, whether the statutory prerequisites for invoking the act were met, it should bear in mind these common law rights as a reason to not interpret it particularly broadly. That's not determinative. This commission should consider all canons of statutory interpretation that likely point in different directions. However, insofar as the legislation sends individuals due process or procedural fairness rights essentially into abeyance, we should be reasonably certain that Parliament intended for it to apply in these circumstances. That's not a condemnation that the government didn't act proportionately here. That will be up for this commission. I don't see evidence that it didn't. But given that a government is not legally obliged to do so, it should consider the long-term implications of that. Merci beaucoup.
Merci, Gerard. Maintenant, j'aimerais demander à Michel Galland. Michel, please.
Thank you. Thank you to the commissioner. Thank you to the moderator, to the fellow panelists, to everyone present, and those of you attending remotely for this opportunity to share some thoughts. It's a privilege to participate and maybe offer something of value. Funding is important to securing any aspirations. It doesn't matter if you're opening a restaurant, if you're starting an industry, if you're going to higher education, or to realize civil society ambitions. Funding enables. There aren't a lot of things that are accomplished without some kind of access to finance, to property, and to resources. So in participating today, I would like to simply survey 3 dimensions of funding and finance, very briefly funding and the charter, a little bit on foreign funding and civil society groups, and a little bit about the appropriateness of these particular financial measures. So let me begin by noting that it hasn't been fully canvassed by the courts at all, but in principle, the idea of fundraising to support a cause, right, or a social movement is protected by the charter freedom guarantees. There was a roundtable this morning. They did talk about constitutional freedoms, and I'm sort of drawing on some discussions with Professor Jamie Cameron, but suffice to underscore that funding animates those freedoms. So organizations do have the right to fundraise, and you can't impose a limit on what they use those funds for. That would fall within freedom of expression. Donating to organizations, lots of people donate. That donative act can constitute associational freedom. My association is by giving, right, by donating. And then again, that action is captured by the freedom of association. Broad human rights law also places the mobilization of resources amongst the activities that freedom of assembly protects. So there is a report, it's May 2022 from the United Nations Human Rights Council, and it's specifically about funding. It's actually specifically about foreign funding, but it specifically states that the right of associations to freely access human, material, and financial resources from domestic, foreign, and international sources is inherent in the right of freedom of association and essential to the existence and effective operations of any associations. So I know there are limits. Some of those were talked about this morning, but simply to underscore that that funding piece is part of those freedoms. And I would also note that the size of a particular funding campaign, so even if someone has surprising success in mobilizing, resources beyond your dreams, that is not ever without more grounds for a state interference. Simply a successful fundraising campaign, galvanizing lots of resources is not on its own any kind of a justification for some kind of state-based interference. So let me say a few things about foreign funding restraints and civil society organizations. As my colleague has commented, sort of democratic and non-democratic orders all resist foreign funding. It's not just a democratic order thing. All orders resist foreign funding. This idea that foreign influence, the meddling of the outsider in the internal affairs of another, it's long been controversial. Usually states, particularly sovereign states, democratic states, reserve unto themselves, no, we have the right to arrange our internal matters, and will resist and sort of shut off their boundaries to the kind of foreign influence, including foreign funding. That resistance, that sort of is sort of just based on this deal that, look, we're accountable as a state. I'm accountable to, particularly through elections, to the domestic populace, and I'm not accountable to an audience anywhere else in the globe. It might be said that the entire project of international law is simply devoted to deliberating upon what's the proper place of external influence on domestic affairs of state. And I have to underscore this too. Any money flowing across a border is foreign funding. So if I am a Mexican expat and I'm working here and I'm sending money home to fund my family in Mexico, that to the Mexican state is foreign funding. If I'm in the UK and I purchase a football team and I'm a Russian billionaire, to the United Kingdom, that is foreign funding. So any funding that crosses a border constitutes some kind of a foreign funding. But what I wanted to note today is that increasingly there has been this recognition of that there's a recognition that states are imposing restraints on foreign funding. This is a new thing. It sort of started maybe in the last 20 years. It's intensified in, say, the last 10, this idea of individual states are going to restrain access to foreign funding. How do they do that? What are the strategies? Well, one strategy is simply requiring that civil society groups, if you're going to go and harvest foreign resources, you must register. So you have to seek the approval of the state before you can go elsewhere. Another one is simply, it's a little more covert, is the adding of different administrative burdens. So you're an organization and you'd like to secure foreign funding. It's the idea that if you want to go after foreign funding, you have to disclose that. You have to file a number of forms. So it impedes, it's harder to secure foreign funding than it is to secure domestic funding. I think one particularly alluded to, maybe by both of my colleagues here, was the idea of a state marginalizing or decrying as illegitimate, or in particular, labeling a domestic organization as a foreign agent as a reason to say no money is flowing here. So that's another strategy. And again, the idea too would be calling a civil society group as a political organization. So what do we have? So in Canada, so those are some of the restraints. In Canada, we do have some restraints on foreign funding, and most of those, I think, as my colleague Jessica Davis has canvassed, most of those connect to elections and the formal political process, basically injunctions against foreign support. So that's the place where we find these restraints on foreign funding. Do we actually see them anywhere else? Well, generally the idea would be, no, we don't generally have specific injunctions, prohibitions on access to foreign funding. However, what we have seen is we have seen some encumbering being imposed on, say, registered charities. So for example, now, this is a result of a few years ago now, if a registered charity, which is just a charity, it's governed under tax law. But if you are a registered charity, if you're a civil society organization that's organized in that way, you actually now have to disclose the presence of foreign funds. So it used to be charities had to disclose broadly how successful are your fundraising efforts, right? How much money did you raise? But now these particular ones in Canada now have to disclose the presence of foreign funding. So it's not a specific restraint, but it certainly is an exercise in opening up, in disclosing the presence of those, resources. So we've seen some of these. I think what's concerning about this to me was when I was originally looking at this, I thought this is going to be your usual suspects, where we're going to see this, maybe some states that sometimes, at least in Western society, tend to maybe think they're a little bit troublesome. But none of these foreign restraints they're applying in the United States, in Europe, and in Canada. So it's in your reasonably well-developed democratic states that are imposing these restraints. And I would be remiss in not pointing out, with respect to foreign funding, that in July 2021, it saw the completion of an Alberta report, and the Alberta report deals specifically with foreign funding and the energy campaign and energy campaigns in Alberta. And it was an inquiry that was called in that regard. So that inquiry, there might be all kinds of other parts of that inquiry you might be uncomfortable with. However, that inquiry in its forensic accounting, so it used an accountant, actually did identify an increase in the funding of our donative sector in Canada over the period of 10 years of foreign dollars. So I think the number it says, this is about 1.6 billion, an increase over that period flowing into Canada. It doesn't track where it's from. There's some sense that a lot of it's from the States, but it does track an increase in foreign funding. And I would be noting, since that inquiry was specifically about foreign funding, the first recommendation that commissioner made was actually that we need to increase the transparency of the financial sector, in particular in connection with registered charities. So I would just note, just sort of mention, in talking about these foreign funding restraints, anytime we introduce an element of disclosure, as you know, right, elements of disclosure, they irritate privacy. So when we seek to introduce, even if the restraints are about introducing and enhancing transparency, those transparency norms irritate privacy. And I say that because generally the act of donating, which my colleague talked about, about donating to any kind of campaign, normally falls within the realm of financial privacy. It's not public. There's no public entitlement to know where I put my donation, my donative dollars. It privacy shelters that kind of freedom. Now, I just note that, sure, if I have no obligation to disclose and yet I freely choose to disclose in some public medium or tell someone what I've done, that's quite different. There I've decided that, look, I'm waiving my financial privacy. But there is always going to be that tension between disclosure and privacy. So let me in the few minutes I have left, let me say a few things about the appropriateness, like turning specifically to the appropriateness or necessity of the particular financial measures that were introduced. I think I would like to highlight here, and I sort of along the lines with my colleague, my colleague, Professor Kennedy, when you're talking about the appropriateness or necessity of the particular financial measures. And what I'd like to simply comment on is this idea that simply because we have an emergency situation once that's decided, that doesn't trump or abrogate the complete application of law. So there is space in which we have to determine and think about, were these particular things appropriate or not? Was these particular regulations necessity or not? And in saying that, it's not sufficient to simply say they worked. The situation dissolved, we solved it. It is not sufficient, because that's to equate effectiveness sort of with appropriateness, and it means that appropriateness has no meaning. Absolutely no meaning. Doesn't matter. Anything is appropriate. So, the example would be, the sledgehammer killing the fly, but so would the fly swatter. And that would say that the sledgehammer is okay. And I'm not commenting on their appropriateness. I'm just outlining some of the things that we have to think about. We have to think about whether these particular measures were appropriate or not. So simply, in talking about whether the appropriateness of the financial regimes or the necessity of these particular financial regimes, let me simply say that the way in which we might be able to discern that would be to at least think broadly about some kind of a proportionality test. So if you're a lawyer, there's an Oakes test, and it's kind of what it is it's kind of a matrix of proportionality. And basically what would that mean? That would be, in a sense, okay, let's look at, we have a response, and that response ought to be sort of minimally impact on individuals, right? So that would be on one side of the equation, while at the same time be designed to immediately lance a particular public order problem. So you have to think about, so this proportionality between the particular measures, right, and their impact on individuals, not as concerned about institutions, more concerned about individuals, and the immediate kind of dealing with the public order situation. And I'm going to end just by adding one more thing to that. So what would be some pieces that might be relevant to this proportionality analysis? Certainly foreign funding would be. It would jostle for some primacy. So if there was foreign funding, I'm not concluding that there was, I think it's been outlined that maybe there wasn't, but the idea of foreign influence, foreign funding would be pretty important in a proportionality analysis. Another thing that would be important, I think, is when people talk about the idea that these measures were temporary, the measures were temporary, but the impact of these financial measures on individuals may not be. And I would simply say this: the Privacy Commissioner has already warned that some information gathered under terrorist finance and suspicious transactions reporting norms that was wrongful or not clear, once it went into the final system, there needed to be a way to purge it, to get it out. So that kind of thing, there was a lingering consequence. So thank you.
Merci beaucoup, Michel. So as the moderator, first I'd like to thank all the experts for their opening remarks presentation. We've covered a lot of ground, but there is more to be covered. Avant de poser des questions, j'aimerais donner la chance aux panélistes, peut-être si ils ou elles ont des questions. Ont des questions ou aimeraient faire des commentaires par rapport à ce que d'autres panélistes ont dit. So I don't know if you have, if there are some who have things to say about what the others said. Jessica Davis?
Yes, I just have one quick question, and it's actually for Michel Gallant, about the not-for-profit corporations and if they have any restrictions or reporting requirements for foreign funding as well. You talked about the charities, but they're different.
I'm not aware of any because generally not-for-profits, the regulation is much lighter, and simply because they don't give tax-deductible receipts, right? So I'm not aware of any. And I would also sort of, just enjoy that, I'm not aware of any restrictions. So there's not-for-profits, there's charities, but also sort of ad hoc civil movements. I'm not sure where they would fit in this, right?
Patrick Leblanc ici. Anyone else would like to ask or say something, comment? Michel Galland?
Sure. One question I would have is sort of generally, sometimes when we talk about, fixing the financial system, and then we talk sometimes about combine that with this idea of, foreign influence. I guess I wonder myself, I have trouble sort of thinking about, well, how are we going to discern? So my example would be, if we're going to fix, there's the problems with the financial system, and we're worried about foreign dollars. And I think of an example like, okay, we're building a church in Winnipeg, and it's funded by dollars that are coming from the Vatican. That's foreign funding. And it could easily, so I wonder about how you think through, how do you legitimately identify, what are the gaps that need to be filled, and what can be left alone?
Patrick Leblanc, I think that's a very good question. In fact, if I can ask and put it in different terms, because I was going to ask the panel to think about that. And in light of what you also said, Michel Galland, in your presentation, and that's maybe to the question of risk. Right? Michel Galland, you talked about, administrative registration, for instance, or disclosure, right? And especially with regards to foreign funding. So would a risk-based approach, I mean, we see it, already the anti-money laundering and terrorism financing is based on this notion of risk. What is the risk, in a way, for the state in terms of national security, which is why we have this. In terms of securities legislation is the same thing, right? There are restrictions, disclosure requirements when it comes to raising funding for financing companies. So in a way, how is that different than raising funding for building a church or for organizing a group, etc. So I'd like to hear the members of the panel, and Christian, please, raise your hand if you want to speak, in terms of what are the risks ultimately that we are talking about here, right? Obviously, the fact that we are talking about foreign funding means that there is a risk. In terms of politics, as Jessica Davis mentioned, influence, undue influence over the political process is a risk, right? You don't want foreign states to influence democratic results in one way or the other. That's why we have rules over funding, etc. But what are other risks that are applicable here? So I don't know if anyone wants to go first. Jessica?
Okay, it's Jessica Davis. So I think you're right to argue that one of the risks is influence. I think another potential risk is compromise. So basically, the way that I see it is if an individual or an organization were to accept foreign funding that is probably intended to buy a certain level of influence with that individual or organization. But there's also the potential for the disclosure of that information to compromise their ability to do their job, or that they won't want that information compromised in the future, which in turn can also have another level of influence. But I think it's a good question. And I would also take a moment to talk about the foreign funding issue. I think, I don't want to be prescriptive here in terms of what should or shouldn't be in any kind of legislation about limits to foreign funding. I think that's needs careful study. It's a very sensitive topic, but I think it is reasonable to start thinking about that in terms of limiting political activity. That might also have some limits to religious activity, because it's very difficult to separate these things out. I don't see that as necessarily a problem. I think that there could be a reasonable way of writing that kind of legislation to make that acceptable to Canada and Canadians, but it is a thing that it's something that we need to consider as we talk about that.
Quelqu'un d'autre? Christian? Ah, oui. D'accord. Christian, please.
So it's probably helpful to differentiate between risk and threat, right? So everything's a risk in one way or another. But a threat is capability and intent. And so I think we always need to ask then, if we have actors who are providing funding, what is their capability in terms of actually influencing democratic institutions or whatever it might be, and what is their intent? And if the intent is nefarious, if the intent is to support illegality, criminality, if there's an anti-democratic intent, I think that would be an important sort of element of distinction. And so that seems to be driving, for instance, these foreign agent registries, that there's a particular concern that certain state entities have fundamental hostile intent and have the capability to follow through on that intent. And so you have to manage the risk very differently than, for instance, some donor, whoever, who's just giving money because she or he or they sympathize with a particular cause.
Merci, Christian. Patrick Leblond ici. Mais l'intention est un enjeu majeur. Mais je vais poser la question, comment on détermine l'intention? Est-ce qu'on demande tout simplement quelles sont les intentions des gens? Est-ce qu'on détermine soi-même, est-ce qu'il y a une agence ou quelqu'un qui dit « Ah, vous avez une intention, une bonne intention ou une mauvaise intention? » Comment on peut déterminer à l'avance l'intention si justement on dit « C'est seulement dans le cas où il y a une menace. » So I don't know, how do you decide on intent and who is responsible? Because I guess there is a danger that it could be abused. Someone could say, "Oh no, you have bad intentions, and therefore, we're not letting you get that foreign funding or even do anything." Je vois Michel Galland qui aimerait répondre.
Yeah, it's not really an answer, but I think this came out of some of the comments that Professor Lauprecht made, was this the part about identifying the foreign funding is one thing, but one reason I think that Canada has some issues on the international stage, even though it hasn't been labeled, I'm not aware of it being labeled as a money laundering haven or a terrorist financing, but I stand to be corrected. But the criteria of both of those is usually financial secrecy is at least one, low tax rates can be one, but also pronounced very strong secrecy rules. So I guess I wonder, and like I said, I'm not that sure. I haven't sort of policed or looked into how strong kind of Canadian protection of the secrecy of transactions that cross the border, actually how that stands up along, say, different countries, which sort of have been labeled sort of, I guess, as secrecy havens. Some parts in the South, some parts in the very center of the United States, some places in the middle of Europe. But like I said, I wasn't aware that we were. But if we are, simply in terms of detecting that kind of foreign funding, the suggestion would be we actually have to enhance disclosure in some way, shape, or form. So to move up the Transparency International, index.
Okay. Merci beaucoup, Michel. Christian, would you, Patrick Lebeau, Christian, would you like to say something about intent and how and who could decide this and how it would play in terms of focusing more on threats than risks?
I'll try to be brief. Look, intelligence is our first line of defense. And so this is why intelligence agencies are subject to different evidentiary threshold regime, for instance, than criminal intelligence. Now, let's look at how well we're actually doing when it comes to, for instance, figuring out intent in terms of financial intelligence. So in 2019 and 2020, FINTRAC had 31.5 million individuals' reports submitted to it. Now, the entire United States had 21.5 million. The United Kingdom had 500,000. So that's 12.5 times more reports in Canada as compared to the US, 96 times more reports compared to the UK. So that's an exceptional defensive regime that provides very high volume, very low quality outputs. In fact, in 2019-2020, FINTRAC made only 2,057 unique disclosures to law enforcement, and most of those disclosures were not particularly useful because they didn't, for instance, draw a broader network in terms of threats and so forth. So we need to actually have a much more robust posture for our intelligence agencies to actually be able, on the one hand, collect the information that they need to discern intent, and then to be able to action that type of intelligence. And when it comes to FINTRAC, for instance, if you read the chapter on FINTRAC, in the Cowan Commission report, it is very clear that FINTRAC does not perform. Why does it not perform? Because it is a complete outlier in terms of financial intelligence agencies among Western democratic allies. So this just sort of as an example that we can have all the conversations about legal particularities that we like. If we have agencies that cannot perform for the purpose of the security, prosperity, and democracy of Canada, then all this is probably nugatory.
Thank you very much, Christian. Jessica?
Yes, I just want to come in a bit on the Cullen Commission information that Christian Leiprecht is presenting. So in my reading of the Cullen Commission, I found a number of factual errors and a number of errors of interpretation. So I think we should be cautious in citing that too closely and being too, using that information too carefully here. Because, you know, when we talk about 2,057 unique disclosures, that doesn't actually tell us anything because there can be hundreds, if not thousands, of individual transaction reports in each one of those disclosures. We don't know how many of the 30 million reports were actually disclosed to law enforcement or intelligence services in those reports. So there's some issues of interpretation around that. And I would also take issue with the idea that all of this FINTRAC intelligence is not useful. Law enforcement and security services have repeatedly told FINTRAC the opposite. In their annual report, they share that information. I worked at FINTRAC, I worked in the Canadian Security Intelligence Service. I've reviewed a number of FINTRAC disclosures. They vary in terms of their usefulness, but they are not universally not useful. And I just want to come in on financial intelligence and the issue of intent. The problem is when we're talking about financial intelligence, we're talking about financial transactions. They don't tell us anything about intent. It's literally just an information, a record of who's sending money to whom. You need an all-source intelligence picture to get that intent. But I also think that when we're looking at foreign donations, there is an implied intent behind that. It's to support the organization, political activity, or individual there. So it kind of makes the whole argument about whether it's threat or risk moot.
Patrick Leblanc, thank you, Jessica.
I do have to, if
Christian,
I may reply
yes?
to that very, very briefly, that what Ms. Davis outlines here is precisely the problem when it comes to effectiveness of government agencies, that there is insufficient transparency for outsiders to measure whether these agencies are actually effective. And what governments do in their own agencies, they will always say about each other that they're all effective. I've yet to find an RCMP report, for instance, that has ever said about any RCMP aspect that the RCMP is not effective at something that it does. So what this means is the state controls the narrative on how effective its own institutions actually are. And that's why inquiries such as this one are so important, because they're some of the very few opportunities to actually shed light and provide some transparency on what actually happens. And I think it is, while there may be some factual issues with the Cowan Commission's report, I think it is very dangerous to call into question the overall conclusions that the Cowan Commission draws, because it is the only measure of objective, independent sort of assessment of the entire regime in Canada and to what extent it actually does or does not serve the public purpose. And I think the Crown Commission's conclusions on that are irrefutable.
Merci, Christian. Anyone else would like to take on this issue of intent or not? Okay, Jessica?
I will come back on the issue of effectiveness and usefulness because Professor Leuprecht did move the bar on that. So we were initially talking about usefulness of FinTrack disclosures, and then he talked about the usefulness of the effectiveness of the regime. I would agree that the regime has plenty of room for improvement. The regime as a whole is largely ineffective in terms of the measurements we would normally associate with that, things like prosecutions of money laundering and terrorist financing offenses. But that doesn't mean that FinTrack disclosures are not useful.
Okay, thank you very much, Jessica. Patrick Leblond. Let's bring it back to foreign funding, which in a way is what I would like us to focus for now, and there are other issues. But in terms of the risks and the intent, and therefore the question of whether there should be disclosures, registration, as mentioned by Michel Galland, and I guess putting it in terms of that she presented it in terms of appropriateness and is it necessary and when is it necessary and who should, and I'm going to use other examples. We know, for instance, when it comes to foreign direct investment, there's the Investment Canada Act, and that has been changed over time. The notion of national security was incorporated, and a lot of the focus has been on state-owned enterprises, for instance, that do invest. So I'm going to try to draw this parallel in terms of, I think, Jessica Davis mentioned, well, foreign funding says something about intent, but it only says about that you support something. It doesn't say in what way, for what purpose, you just support it. Would it make sense, and this is obviously open to all the panelists, to draw categories? Say that state funding, for instance, from any state is illegal, or at least, and then obviously there is the issue of, well, the state could say, well, we're going to fund some private organization that is then going to fund something. So you would have to go back to the financial chain. Is there a way, or is there a logic to kind of having categories on saying, well, if it's individuals, it's okay. If it's corporations, well, then that goes in another category. If it's states, it goes, like no states, for instance. In terms of maybe requiring the kinds of disclosures, and then who discloses? Is it the party that seeks funding, or is it the party that brings in the funding? Where does this disclosure take, right? Donc, je ne sais pas si quelqu'un aimerait peut-être discuter de cet enjeu, de comment on peut justement approcher cette question de transparence, ultimement. Michel Galland?
Sure. I would say that generally there's certainly been a lot of work here in Canada, and sort of it's this global regime, both in a sort of a criminal context and a terrorist finance intent, but also in a tax context. Two separate global regimes, but they're both about increasing transparency. And it's not simply about, but it's largely about crossing borders. So the tax evasion or avoidance to which my colleague referred, a lot of that activity is because it's enabled by a border. So even the CRA can go as far as the border, but they can't look beyond, then they got to start asking questions. But there's been a lot of work, I think, and it has a long way to go in terms of transparency. So one example would be, it's been, I don't know how many years they've been asking us to create a corporate registry of beneficial ownership. And that's simply a place that, you find a corporation and you know who actually benefits from it. Right, it's been forever, and we're finally BC's moving. So a lot of places. So that general work I think is happening, but as I said, it's been very slow. But related to that, and maybe I think somebody else can probably answer this, because the transparency piece is from the top down. I usually sort of work from the bottom up. So if I were looking at, I would start with proliferation. So I would know that, say there was a nuclear facility and money was destined for proliferation. And then I would look up from there to the regimes that governed or that allowed the transparency, or why didn't we see this? But one question I have in terms of that is, I can't get my head around, what is it about this particular, what was going on in Ottawa in January and February that would have triggered a financial response? So, you know, when I think of financial reporting, I think of suspicious transactions reporting. So, you know, $12,000 deposit from somebody who has, you know, no resources, it might trigger a suspicious transaction report. But I guess I wonder generally, so in terms of transparency, if we had transparency, what is it about what was happening, as I said, in January and February, and sort of in Ottawa, but also across the country, that would have triggered some financial knowledge? Like I said, that's...
Merci, Michel. Patrick Leblanc. So if I can maybe go further, Michel, sorry, does it make sense to say, well, because if I understand, like, even if we had information on, you know, and I guess we, you know, whether it on these transactions, would it have changed anything, right? In the sense, I guess, and then this as it was raised, right, by if those crowdfunding platforms had, you know, been registered and they had collected information, would it have changed anything? So, Jessica?
Yeah, I just want to say that FINTRAC was in a position to collect a lot of that information. When those transactions hit the Canadian side of the transaction, anything over $10,000 or more would have been reported to FINTRAC. The gap is in the suspicious transaction reports, although institutions can absolutely file that as well. And you know, looking at this whole convoy finance issue, I think I've made no secret that I'm not a particular fan of how things went in Ottawa, being a resident here. But I don't see any way that enhancing these regulations in this way would have provided the government or FINTRAC or law enforcement or security agencies with any additional information that would have been particularly useful to countering the protest.
Thank you, Jessica. Patrick Leblanc. Anyone else who would like to add? Because
I think it's the point.
Michel Galland.
Sorry, I think it's the point Professor Michel Cumin made about that even if you regulate the crowdfunding platforms is one thing, but as I understand it, if I put a sign on the internet that says send me money and it's got my bank account, that it's regulated by the financial institution. It's an exercise in crowdfunding, but it doesn't touch any kind of crowdfunding. I think that's the point.
Yes. And I think you made that point as well.
Michel Cumin, yes.
Oh, sorry, Michel Cumin, yes, that's right. It is possible to launch a crowdfunding campaign without using a crowdfunding platform. All you need to do is create a page on your website for people to give donations. And in that case, while you're using a money services provider, is that what they're called in English? A money services provider, and that would therefore be reported to FINTRAC, is that correct? Yes. So I don't understand what the added value is of also getting reporting from the crowdfunding platforms themselves.
Merci, Michel Cumin. Patrick Leblanc here. Is it fair to say, at least from my perspective, going back to the what happened in Ottawa in last winter, that in a way the money issue kind of came in because the occupation, if we want to call it that, or the convoy, lasted for much longer than, I guess everyone expected or hoped. And then it was seen as a way to put pressure on those who, in a way, overstayed their welcome. So originally, it seems, and many of you have talked about this, right? And I think Michel Galland and Michel Cumin made it quite clear that, well, funding is good for democracy in a way, right? Funding protests is something that we should allow and potentially even encourage, right? That people have a right to demonstrate, they have a right to get together and say what they like or don't like. It seems that, well, it's when kind of this turn, then the money parts was seen as a way, well, if we cut the funding, then they won't be able to do what they want. I don't know if like, it seems that we're talking about two things here. And when is it that, you know, we flip into the other part? And where, and would the registration, the disclosures, the transparency change anything to that? Like, ultimately, was it just to say, okay, now this is no longer just a protest, right? It's an occupation. We need to get, we've used, let's say, the whatever means, we couldn't do it. And we think that if we cut the funding to these people, and it's going to prevent new people from coming, because we're going to threaten them. I have questions about that later. But would any of these disclosures, transparency, change that? I don't know if I'm making myself clear, but it seems that there are two things. One is kind of what happens before the money kind of gets there, right? Like, in a way, when we're talking about terrorism financing, we don't want them to get the money even before. We want the money we want to be able to track it so that we can prevent some attack. But in this case, would it have changed anything? Jessica, you're nodding. Maybe.
Yeah, so I'm trying to sort of pick out the pieces of your question there. So I think that there's two things, and I'll use a framework for this. So I see the way that the government sought to counter the financing of the protests and the occupation in two different ways. One was organizational. So by targeting the crowdfunding campaigns, which were drawing in those large sums of money, the foreign funding piece largely came from those crowdfunding campaigns. They were seeking to address that organizational piece because it was so, or the movement piece, I think is a better way to frame that. And the concern for Canadians really came from that movement level funding that was happening from people who are identifying as being outside of Canada. And I use that language very specifically because there was no identity verification being done on who was actually donating and where they were located. It was just what they were saying. So I think we need to be quite careful about that. So that was the first piece. The operational funding is what I would consider to be on the ground funding. And that's where we get into questions about the sort of the effectiveness of the measures. To my mind, telling people that you're going to freeze their bank accounts unless you leave Ottawa could facilitate a peaceful conclusion to a situation. And it indicates a level of seriousness on the part of the government. I'm leaving aside all questions about proportionality and whatnot there. And I think that that's quite a useful way to think about it. The thing that bothers me, though, about what I've heard from the Commission so far is the government's assertions about its effectiveness with no evidence. I've heard repeatedly from government officials saying that in public statements and at this Commission that these measures were effective, but we haven't seen any evidence about whether or not, why were they effective? Whose money was frozen that really spurred people to leave Ottawa? The process tracing of that activity. And I think that's what concerns me.
Je voudrais peut-être...
Oui, Michel Comin.
Michel Comin, je voudrais peut-être juste ajouter quelque chose aussi. Pour moi, le moment où tout ça est devenu vraiment illégitime, c'est lorsqu'il y a des actes criminels qui ont commencé à être commis par les manifestants. Et une des mesures qui a été prise, je ne sais pas si elle a été efficace, mais je soulève quand même, je souligne, c'est l'ordonnance de blocage sur le fondement de l'article 490.8 du Code criminel, qui permet donc de bloquer ou de geler des fonds si on croit que ces fonds vont être employés pour commettre une infraction criminelle grave. Il me semble que ça, c'est un exemple d'une mesure qui semble tout de même efficace, mais en tout cas, c'est pour moi le moment où toute cette histoire est devenue vraiment illégitime du point de vue socio-financement, c'est lorsque on a vu que ces fonds-là allaient être utilisés pour commettre des actes criminels. Voilà, merci.
Merci beaucoup, Michel. Gerard, would you... I have a question, Patrick Leblanc. I have a question for Gerard, and this. You talked about notice in the procedural fairness. Mm-hmm. That normally before someone's assets get seized or frozen, they should receive notice. And it was mentioned by the others that, and this is what happened. That in a way is like, okay, once the Emergencies Act was invoked, the regulations came in. And it was like, okay, now if you don't leave Ottawa, or if you come to Ottawa, you risk having your financial assets, your bank account frozen and all that. Would that be considered as notice in terms of procedural fairness? Like, in a way, you are warned. I just wonder what your opinion on that, Joe.
No, that's really interesting. And you could definitely make an argument that for everyone who is coming, it is notice. For people who are there, it kind of is, all right, it's a dispersal order that's not a dispersal order, so to speak. So it's kind of stretching the definition, I think, of notice. And it still doesn't really get around to determine whose assets get frozen. That remains a little bit of an uncertainty. And so that is where I think, from a procedural fairness perspective, it gets a little more complicated, unless you just view this as a quasi-legislative action, and then that's notice enough.
Patrick Leblanc. Christian.
Christian Leprecht. I think this really gets at the heart of sort of the challenge that moving beyond the invocation of the act is simply a means to an end, and it somehow had the strategic effect that the public or the government was looking for. And I think so. These measures of notice then get us to, I think, 4 other sort of thresholds, which is, was it proportional? Was it necessary? Was it reasonable? And was it sort of and the efficacy, so efficacious, efficient. And so what does the sequencing look like in order to be able to then have on your matrix being able to check these off? And so I think the financial piece really came as a way to substitute for the relatively ineffectiveness of the initial law enforcement response, also on the financial side, because these financial investigations are some of the most complex investigations that you can possibly lead on a criminal enforcement, criminal intelligence side. And we're simply not postured with the people who can actually do these investigations. So we're having, I think, the conversation that we're having today as a way that the government substituted for the fact that we simply on the enforcement side didn't have the appropriate capacities and competencies if we had been able to leverage these the way other countries, Australia, the United States, France, Germany, leverage these in protests effectively, then we don't have to resort to these extraordinary measures. And so I think they're trying to understand, how do we get ourselves to some benchmark measures as to under what circumstances it might be appropriate to then use these second order effects, such as the financial measures that we're talking about, and when these effects are proportional, necessary, reasonable, and efficacious. That's, I think, the heart of the matter.
Patrick Leblanc, merci Christian. I guess ça soulève une question pour moi, justement cette notion de notification. Est-ce que, Gerard, vous avez dit que, pour les gens qui étaient à l'extérieur, qui peut-être voulaient revenir passer le week-end à Ottawa pour s'amuser et manifester, OK, ça aurait été suffisant de leur dire, écoutez, si vous venez, on risque de peut-être geler votre compte bancaire, vos cartes, etc. Pour les gens qui étaient déjà là, peut-être pas. Mais est-ce que, parce que là, après ça, c'est comment on fait pour les identifier et qui on identifie exactement. Mais est-ce que si on avait dit, écoutez, quelqu'un passe et demande le nom des gens qui sont tous présents dans un périmètre et on dit, voici la liste de toutes ces personnes qui à telle date étaient présentes et si elles sont encore présentes dans 48 heures, on va donner l'ordre aux institutions financières de bloquer. Est-ce que ça serait acceptable, disons?
Well, je vais répondre en anglais parce que je veux être plus précis que possible. Well, is it okay? Let's. In times of crisis, traditional rules of procedural fairness can be modified. We have to accept that we can't always have gold-plated process going on here. So in that sense, to some extent, a hammer is I'm not completely opposed to it. Where I think it becomes more problematic is how did the banks know whose accounts to freeze? And if they felt they made a mistake, like what sort of disincentive is there on the bank to not do it? How do they know the person didn't leave? The fact that there wasn't a centralized authority is a little bit of a problem as well here. And the fact that there was no challenge after the fact is a bit of a problem as well. Like, going only for efficaciousness, this may very well have been efficacious, and therefore, in some cases, I'm not going to argue that it wasn't efficacious or that it wasn't even justified in particular situations. I think the problem arises, as you noted, it was implicit in your question, that we don't know how the banks made this decision. We don't know if the banks did it with someone who actually got the message and left. And that's where the lack of any individual protection is a bit problematic. And look, in an emergency, some of this is someone's going to fall through the cracks. But the lack of any kind of ability to challenge, the lack of any kind of way to say, no, I left, I got the message, and the bank had no incentive to accept it. Like the person could go into their bank account in Toronto and say, look, I'm back, but the bank wasn't obliged or had no incentive to take it off per se. That's where I think it becomes slightly more problematic from a procedural perspective.
Merci, Gerard. Michel Galland?
I could just add, just in terms of the notice piece, the idea of affecting sort of rights, and I think this has been mentioned before, would be, the financial measures touched the stuff of designated people, but the stuff of designated people, like most of us, a lot of that stuff is jointly owned or owned in common. So in thinking about in thinking about whether it was proportionate, sure, you jointly own a house or you jointly own a bank account, and one of those people has nothing to do with, maybe they're even estranged and they still have an account sitting there. So I'm just adding that to sort of the discourse on the lack of any kind of sense of not only of notice, but of anything.
Thank you, Michel. Jessica?
Yes, I just want to come in on this question about how banks, if they're not told who the designated people are, very specifically how they identify them. And it comes through social media and media monitoring, so identifying people through that means, and then also through accounts. So if they're conducting transactions in Ottawa and they're not normally residents here, withdrawals, purchases, et cetera. So there's a couple of different ways that happens, which I think raises some issues in terms of whether or not outside the context of money laundering and terrorist financing, because we are talking outside of that context, whether that kind of surveillance of the population should be taking place. And then my next issue for us to consider, of course, is then what happens with that information? When banks have this information that individuals were designated people, or they've determined that they were designated people under the measures, they don't forget that. They remember, and that becomes part of their de-risking process. And banks are risk-averse institutions. So does this continue to impact the ability of these designated people to obtain financial services and financial products? I don't think that we've explored that in any real way. I don't think that there's been a lot of information about that, but I think that there's a real risk and very probable implications for the individuals who were designated.
Thank you, Jessica. Gerard?
Yeah, Gerard Kennedy, just to add a little bit on that, I realize we're outside of the terrorist financing context here, but many of the principles I think are analogous in terms of there are situations where you will want to freeze the account because it's really urgent. But as Professor Gallant noted, there are circumstances where it could be a joint account between someone who's genuinely engaged in terrorist financing and a completely innocent party, which is why there's a process to challenge that, which is why I think, and maybe it couldn't be exactly analogous, some sort of ability to challenge property seized under the Emergencies Act, analogous to under the Terrorist Financing Act, the Money Laundering and Terrorist Financing Act, is probably a good idea. And to Jessica's point that banks have the duty ultimately to do this, banks are not experienced in administrative law in the way that many aspects of the agents of the government are, which is why I suggest that the designation should probably be done by a centralized authority. I don't think that what affects the legality of what went on in February, or even whether it was necessary, reasonable, proportionate. It may have been all that thing. But I still think it would be better policy to have it done by an entity that's learned in admin law principles. And yes, there might be some sort of brief period where someone's bank account is frozen unnecessarily, but I think it would mitigate it, and the incentive for the bank to do nothing is not quite the same as if there's an emergency regulator that has precisely this purpose.
Merci, Gerard. Patrick Leblond. Jessica, if I can go back to what you said, because I think this is an important point in terms of the surveillance and what happens after, right? Once you've been designated either officially by some authority or unofficially by a bank within the context of the regulations or something else, right? And you said that there's always the potential that banks don't forget, that they will use this in their risk assessment of customers, either existing ones or potential ones. And I don't know, and this is open to everyone, but should there be some kind of process, whether, obviously it's in a crisis situations like the one that we experienced last winter, or if there is something in a way more systematic put in place where people should have some kind of appeal mechanism or transparency where they could look at their risk profile, or I'm not even sure if it's possible, but because I'm wondering, for instance, what if someone, and we know, participates in a protest and they do so, in with good intentions, to go back to intent that Christian was talking about. They take part in a protest, maybe things get out of hand, they leave, they might get designated just because they were there, and then all of a sudden they have, a sort of black mark associated with their names. Do we know if that black mark stays forever? Does it disappear? Does it have an impact? Is there any way of finding out? I'm just wondering, because you raise an important issue, and obviously then there can be associations. It's like, oh, well, these kinds of people participate in those kinds of activities which potentially could be nefarious to the state or the economy or something like that. And so I'm just wondering, is there a danger? And then what remedies or safeguards should we put in place, even if to deal with the situation, but then what happens afterwards? I'm thinking young people who demonstrate and might be arrested, and then they have, some kind of record that affects the rest of their lives, even though, they might have changed their lives. So in this context, is there something similar, and what safeguards could we put in place to prevent abuse or discrimination in terms of the surveillance and even doing business? So I asked you, Jessica, but obviously this is open to the others as well.
Okay, if I may, I'll start, and then hopefully there's plenty of room for others to come in on this. My understanding of bank processes is that it's individual banks that are making those determinations about how much information they're keeping on their clients for any given time. The remedy is actually one of the critiques of our system, which is that there's strict privacy regulations around what banks can share with each other. So if an individual were to be debanked by one bank, that information could not be shared with another bank. So the individual in question could, in this example, go to another bank, and that bank wouldn't have the information about them having been designated, et cetera. So the remedy is actually in one of the critiques of the system.
Patrick Leblond, can I just maybe then go back to, okay, that's a very good point, but what if there is a list of designated individuals, which is shared across the financial system? So then you lose that privacy, right? Now you're on a list. You're blacklisted in a way for a particular situation. But is there a risk that then that particular situation then associates you as a risky individual for financial purposes going forward?
Jessica Davis here. So I think that that's a question for the banks about how they handle that internal information and whether or not they'll be considering that going forward in their client decisions.
Thank you. Quelqu'un d'autre veut, Patrick Leblond, quelqu'un d'autre veut ajouter quelque chose? Christian?
I just want to introduce the Australian example here, right? So if you look at the fines that were leveled against Westpac and Combank, for instance, I mean, these are huge fines. And what that suggests is that the banks aren't actually terribly concerned about the risk that any one individual that's making hundreds or thousands of potentially quite dubious transactions poses. So the banking culture in Canada may be different, but the Australian example suggests that, well, I think this is an important point that you raise that affects, clearly affects, has potential serious impact on individuals. The Australian example suggests that we should be concerned about quite the opposite on the part of banks.
Merci, Christian. I see one hand, so Gerard, please.
Okay, I actually have a question that I'd like to ask my colleagues who are more substantive subject matter experts in this area, further to your earlier question whether we have any questions. Many of the individuals financing the people in February may not have been here, and yet I don't think they fall within the definition of designated persons whose assets were frozen. So, and they may have been the people who actually may have been most efficacious to freeze the bank accounts of. And does that affect your opinion about what policy should be going forward, how proportional things were, of that nature?
Jessica?
Thank you for that.
You can also respond to Christian. I thought.
Yeah, so just on that, I think I'd have to go back to the regulations because I think that there was an interesting provision about financing of the protests, but so before I can't answer that without looking at those again. And then just on the example that Christian Leuprecht brought up, I just want to bring up the idea of profit motive for banks though as well. So, you know, Westpac and some of these big organizations that have been fined these huge amounts, there's a significant profit motive for the banks in continuing that financial relationship that does not exist for individuals. So I think that the risk for individuals is far, far greater than for those kinds of, you know, large entities.
Thank you. Michel Galland?
I would just say, as it's always difficult given jurisdiction to attach something. So it's the same reason, again, in the opening presentation, he talked about taxation. The reason you put your assets outside of Canada is a jurisdiction concern, right? It's more difficult to tax them. Not saying it's a crime, but it's more difficult when anything is offshore. It doesn't matter what it is, an asset in relation to tax or anything else. It's much more difficult for the Canadian state to do anything against that, particularly if you're not a Canadian. So if you had somebody, so anything, sort of any resource, the only place you can catch it is you can catch it at the border. But if it involves sort of a donor in Australia or in, Nigeria or in the United States, the reach of Canadian laws obviously doesn't cross that border. Now, I would say there are relationships amongst banks. So Canada's never done this, but the U.S. has certainly seized little thing. It's just called the correspondent accounts. But basically what they have done is if you don't follow what we want you to do, we will seize anything that's remotely related to your bank here. So say the Bank of Canada has what's called a correspondent account in New York. But as far as I know, we've never done that. But that whole question about jurisdiction is a difficult one. It's an absolutely difficult one.
Merci, Michel. Michel Comine, because we're going to take on va faire la pause. Alors, je ne sais pas si, Michel, vous voulez ajouter quelque chose?
Non, c'est très bien, merci.
Ça va? OK. Alors, je crois qu'on va faire la pause maintenant d'une demi-heure et puis on reprend à 16h30. So.
Super. Oui.
Question.
Ah oui.
Je pensais un peu avec
Ouais.
ou autres agences.
The commission is reconvened. La commission reprend.
Alors, nous sommes de retour, Patrick Leblond. Voilà, Christian, il est là. Donc, nous avons quelques petites questions et ensuite une question, en fait, deux questions d'ordre plus d'importance. La première, c'est peut-être, je pense, une question probablement pour Jessica Davis. Dans un contexte de crise, lorsque justement, une des questions qui était posée, c'est les délais, par exemple, entre le moment, par exemple, où peut-être une transaction est identifiée et ensuite l'information est remise ou transmise à CANAF et ensuite elle était analysée. Est-ce que ces délais-là sont importants ou ça se fait rapidement? Jessica, do you know?
Oui, généralement, pendant une crise, je dirais que les opérations financières sont soumises à CANAF rapidement. Alors, généralement, je dirais que ça se prend dans des opérations douteuses. En général, 24 heures ou moins.
Et pour l'analyse ensuite, avant de peut-être dire, OK, c'est
Oui, c'est
actionable.
Oui,
j'utilise le terme.
même chose. Certainement, s'il n'y a pas beaucoup d'opérations financières, ça ne prend pas beaucoup de temps pour faire l'analyse et déterminer si ça peut être donné à CICIS ou autre agence. Alors, je dirais que oui, c'est rapide encore. À CANAF, ça peut prendre quelques heures, quelques jours, dépendant des circonstances.
Okay.
Dans une situation urgente. Mais
oui.
c'est aussi une question à poser à CANAF.
Oui, oui. Non, bien sûr, mais on se demandait. OK, donc effectivement, des délais très courts. Merci, Jessica. In terms of the second point that we had some discussions, one thing that was mentioned, and we talked about a lot of the potential longer-term unintended consequences for people who might be designated. One thing that was mentioned is the not only in terms of the banks, but what would happen, let's say, if someone's bank account or money assets were seized or frozen, and then they missed payments on their mortgage or on the couch that they bought or something, and then obviously their credit score was affected. Again, when we think about proportionality, should these things be taken into account, the longer term effect? Because then, is there any redress? For instance, say, hey, yeah, I missed my payment because I didn't have access to my bank account because someone froze it, because I went to a protest, or I gave money to people who went to a protest. So I'm curious to hear whether such unintended consequences, potential unintended consequences, should be considered in the kind of proportionality tests when actually implementing or putting in place these kinds of measures. So I'm putting it open to everyone. So Michel Galland?
Sure. I'm not sure I would use the language of unintended, but certainly in thinking about the ruminating on proportionality, it would have been known. So when I referred to the privacy, or at least when I referred to the privacy commissioner has a report which simply talks about sort of stagnant financial information. So information, she's talking in the context of terrorist finance and suspicious transactions. So there's a little cloud on someone, and it's been investigated and dismissed. But the point she makes is there needs to be a mechanism for clearly purging that. So in the same, we don't have mechanisms. Somebody else wrote about this, something called the right to be forgotten, right? The right to have information actually purged and destroyed. But just in response to what you said, I don't think by any stretch it was unintended. I'm not sure what intention means, but it would have been known, because it's always been like it's known that once something descends, right? As I said in her context, talking about once privacy and some information, yeah, it's there, right? So it would have been known that information was there. So this idea about was it temporary or not at the time, that piece that something might potentially linger would have been a piece that ought to, I think, have gone into, as you say, the analysis of whether this is proportionate or not. It's not temporary if you're, for some whose relationships or financial matters would have been disrupted, maybe not permanently, but as you say, the severity would be even something like, our bank account is closed and we live on the margins, and, we've the consequences there. But in this case, if you have one bank account and it goes beyond, then you're really in a difficulty. So,
Jessica?
Yes, I think that you're right to consider those things as some of the consequences of the asset freezing. The issue of there being a lack of redress, I think, is also well worth considering. How do you go to a credit agency and fix that? The only thing that I will say that on this is that the measures were in place for a short period of time. So I think that reduces some of those potential consequences because 5 days is, in some cases, might make a difference for some people, but it's it's not a full pay cycle. It's not a full month. So I think that there's some considerations there as well.
Gerard.
And just to build on that, I think that may be an argument that the measures were proportionate on the facts of what occurred in February, while also recognizing that insofar as this commission has a policy role and is recommending how to make sure that these more profound consequences are mitigated in the future, depending on whether or not it believes the threshold for invoking the act was met, there are recommendations that could be made to mitigate those concerns.
Mm-hmm.
Merci. Patrick Leblond. J'aimerais retourner à l'enjeu du financement étranger, mais dans un contexte de l'ère numérique. Okay. So now, well, during the protests and then afterwards, crowdfunding platforms have to be registered or have to register with FinTrack. Before that, also, crypto exchanges, wallets operating in Canada have to do so. But I guess one of the questions, and I'd like to hear the panelists, is and Jessica mentioned obviously the compliance burden that it puts on an entity like FinTrack. But even beyond that, how can, I'm not sure, but if you have foreign entities, and I assume if there is a crowdfunding platform somewhere in the world or a crypto exchange or a crypto wallet service, whatever they call themselves, you don't necessarily know or even care who's your clients, right? Especially if where you're physically located, at least legally, there is no requirement for, know your clients' information. You may not know that, this person's from Canada. You may not even know that you have technically now that you have someone who has put money on your platform or donated money to your platform or is going to receive money from your platform, that you should be registered. So first of all, it's very difficult for an entity like FinTrack to actually scour the world to find out, okay, who's doing business in Canada, who's not. So that's the first thing. The second thing is, even if that were possible, say, hey, you're not registered. So now you have to register. And then, after, I guess, a certain time, you find out that the platform, crowdfunding, crypto, is not registered. Then what? What happens? Does FinTrack say, you're not registered, you're not complying, we're going to shut you down? Well, that's not going to happen, especially if that platform is not in Canada. They can't really do that. Then can you block a website, like an actual IP address from this platform, say now Canadians no longer have access to that? Is that, and is that possible, or what is the process for doing that? And then even if you could do that, then isn't there this platform might just say, okay, well, now we're blocked here. We'll just create another IP address where people can go and do the same business they were doing before. And then you have to go through the whole process. And this kind of cat and mouse. So the big question is, even if we want to have this level of registration, disclosure, transparency, compliance, is it even possible, feasible? So I see Michel, who's now wants to say a lot of things. Michel Galland.
Sorry, yeah, I don't think it's possible, and I don't think it would be a good idea. So it's possible under a new technologically driven model, which my colleague referred to, whether you could have some kind of centralized system wherein Canadians were only allowed by law to use an electronic currency. You could have that. I think that's a very, very bad idea. It means that everything is capable of surveillance, regardless of what we've placed all the information in a central place. So I think that's bad. Not a good idea. I think facilitating exchanges is fine, but that particular model, which has come up recently, is not a great idea at all. And nor would I be, it's very, very delicate when the state starts blocking websites. If we put this in the context of China and you talk about sort of, well, when I'm there, I can't access these websites, what's going on, which to me are quite normal That's a very, very delicate and a dangerous area. So whether it's to shut off funding or to shut off, access to information, I mean, there are limits on the things maybe that we should have access to, but distaste or short of certain really extremes, the state's ability to sort of shut off rents. And I say that because we've seen that. We've seen that right now in the context of Russia. We've seen websites shut down, which reasonable people, I think, would completely disagree onto whether those websites should have, they would have said that was my source of information and now it's shifted. So I'm just sort of responding to that. I'm really concerned. I would be very, very concerned about giving the state that kind of authority. Sorry.
Merci, Michel. Jessica?
Yeah, so it's a very complicated scenario that you've painted for us. But I think that this points to one of my recommendations, which was that the government and FinTrack and Department of Finance as a policy setters should be conducting public consultations on these kinds of things, because this is the kind of scenario they should be test driving. How are we reasonably going to enforce these regulations? And then, just a little bit on the client issue, there is increasingly, crypto exchanges are increasingly regulated and there are know your customer requirements. Not all crypto exchanges are as good at that as others. And there's still, of course, the wallet-to-wallet issue that, unhosted wallets can conduct these transactions across borders, and attributing those wallets to any individual is exceptionally difficult unless you have quite good access to the individual's devices or other sources of intelligence. So I think that there's a lot of holes in this regulation, but not a lot of benefits necessarily.
But can I,
Michel Galland? Yes.
Sorry, Michel Galland, yeah. I just because I think in something you wrote, you mentioned at some point in time, you talked about these things that are called, I think, Hawala networks or informal value transfer networks. So I'm simply asking you whether your idea is that actually, whether you see any value in this, in the fact that the state actually, so for these informal value transfer networks are outside of the formal banking system, and a lot of people have issues with them, but I wonder if you see any benefits with that kind of, because you mentioned cryptocurrency, so the idea of a decentralized system, the lack of state surveillance, the same, and I'm just drawing the parallel between the Hawala might have been an older version of a deregulator, the Mexico peso network might have been another. So I'm just wondering if you see any value in those kind of networks that aren't subject to intense regulation.
Jessica?
Yes. Most Hawalas are actually meant to be regulated under anti-money laundering legislation in different countries. They're meant to be money service businesses. A lot of them are not regulated because they don't register or they just operate outside of those regulated channels. The International Anti-Money Laundering Counter-Terrorist Financing Regime has been trying to address this issue for many years. Hawala is an informal value transfer system. It's been there's a lot of myths around it, I think, but it's basically just a way to send money. It's less expensive, it's faster, it has greater access anywhere in the world than most banks would aspire to that. The issue, of course, comes in terms of their reluctance to report. There's a tremendous value in terms of moving remittances from the developed world to the developing world. The issue, of course, becomes when illicit actors take advantage of those same benefits to move funds. And that's sort of where the issue is. But, in Canada, I'll just conclude by saying Hawalas, they exist. They should almost exclusively be registered as money service businesses. But that's also part of FinTrack's remit, is to figure out who's not registering and get them to register or fine them or refer for criminal compliance. So.
Thank you, Jessica. Patrick Leblond. And I guess it goes back to this question of to what extent is it feasible, once there is a registration requirement for whatever funding or financial entity for FinTrack, who's ultimately responsible for ensuring compliance, to actually do so. Because I guess it's very hard to identify something that you don't really know exists, and no one is kind of out there and say, hey, I'm here. And even more so if it's outside of Canada's borders, somewhere on the Ethernet or even on the dark web, for that matter. But I think it raises an issue in terms of, does it mean that ultimately you need more resources, or even in fact, even if you had all the resources in the world, it would not even be possible to actually do so. So I guess I just wanted to bring that up, because to me it seems an important issue to think about when, if some people think that the answer is just, oh, well, just require them to register and comply, then we're done. It seems that it's, as you mentioned, it raises a number of issues, obviously, whether it's privacy, whether it's freedom, access to information, to information, or even in terms of efficacy. Christian, please.
Well, it's a really pertinent conversation, because if we want to solve the problems of tomorrow rather than the problems of today, then of course we need to prepare for a world where the banks of today are no longer going to be the central financial institutions that we have today. So we're not going to necessarily have a future next time this happens where we can just go to 6 banks and ask them to identify sort of the key, the key sort of nefarious, designate the nefarious individuals. But what we can do is, we live in a world where I think we now have about 27,000 cryptocurrencies, but these have very different standards. And once you get into altcoin, for instance, then you have significantly less intentionally much less transparency and ability to trace and so forth. So what we can do is set standards with regards to what sort of transparency, for instance, is required for the sort of digital currencies that crowdfunding platforms are subject to sort of under regulation. And to some extent, that's already happening in the marketplace, because the marketplace is sorting out already cryptocurrencies based on some certain benchmarks and transparency and so forth.
Merci, Christian. Patrick Leblond. I guess, and this I think will be the last element that we'll talk about. And I, in a way, as Christian just mentioned, we have to think about this, and I think a lot of discussion has been about, going forward. And one of the questions, and it was already kind of discussed, I think it was Christian in his original presentation, the question of in a way seizing assets, or the risk or the threat of freezing assets, financial assets, and to what extent it represents, I think there are two things. One is to what extent it represents a risk to the overall financial system in terms of people's trust in the system, right? And going to also what Michel Galland said about, in a way, the fundamental right of getting money for causes, if we want, right? Or to organize protests, in a democracy. And is there a risk that people, as a result of what happened and what could happen in the past, will now feel that, hey, if I put my money in a regular bank account, could it be frozen? If I give money to a cause and all of a sudden that cause somehow doesn't quite turn out how we thought it would be, because some individuals, not all of them or some of them, decided to use the money for, in a way, not things that we had planned for. And all of a sudden, because I gave, my bank account is frozen, or I have this cloud, as Michel mentioned, over my head. So therefore, either I'm not going to give any more money, so that obviously has an impact, that people's ability to collect funding, or I'm going to try to avoid the traditional financial systems. And I think it was Christian who said, well, are they going to move in a way to less regulated, darker corners of the financial system, which obviously have their own consequences in terms of, potentially as consumers losing their money, losing the value of their financial assets and all that. So I'd like, we have 10 minutes left, or actually 9 minutes. I don't know if we could, what are your thoughts in a way, in kind of the grand scheme of things? Is there, and again, going back to this proportionality element that Michel Galland raised, is the freezing of assets or the seizing of assets, is there a greater risk to the system itself and the trust that people have in the financial system? I don't know qui aimerait commencer pour conclure sur le niveau très macro. Michel Galland?
Sure. I'm not generally in favor of more law, right? More regulation. I mean, prudent, maybe prudent, targeted regulation, yes. I would simply underscore in terms of like watching and concerned with financial activity, there is a balance between the amount of information that any state ought to know, right? And an amount that ought to be private, even that privacy might offend someone. So we usually use the language of crime to discern that. I'm not really saying that's what terrorist finance and those laws do. But it seems to me we're sort of, to go beyond that, it to me is quite frightening. And the reason when I mentioned that I mentioned sort of in the future our state and many states having the capacity to regulate everything, that is there are templates you can see of this ability happening, right? So this ability to actually watch every single financial transaction. Now we talk about those as though, well, the state won't, whatever, but I would be concerned. I would be seriously concerned about moving to a system where everything was in one place, that it could be, right? Because once it could be, then the next time we'd be, maybe we don't like this thing, let's check, right? We said we wouldn't unlock the door, but now we have good reason to, so we'll break the lock and see what's in there. So seriously concerned about that. And, my final comment would be, I have this as when we think about these things, sort of thinking about the inquiry and the need to be consistent, keeps resonating with me is this might not have been, your particular social movement, your particular protest, but the next one might be.
Merci, Michel. Gerard?
Yeah, I just think that goes back to a point I made earlier that insofar as individuals' property rights were limited in this situation, the prerequisites to do so should not be interpreted broadly when there's genuine ambiguity about that. And I just think this underscores that, because one of the reasons is that limiting individuals' rights, even when we understand it's for a problem that's really got to be resolved, is going to have unintended negative consequences. And we don't want to have those unintended negative consequences unless we're sure they were quasi-intended negative consequences. And I also think this underscores what I said earlier, that it may be best that the bank is not making the decision on whose assets to freeze, because then individuals stop trusting the bank as a bank. And banks may not be the most sympathetic entities in our society, but they play a very key role, and they're very risk adverse. Like whenever I teach like certain discovery rules, it's always the bank that has to be told exactly what it's going to do. It wants a court order, and because it's going to avoid liability at all costs. So having the bank not make the decision is probably, in this exceptional circumstance where the bank has to freeze your assets, because occasionally it will have to, I think it shouldn't be the entity that's applying its discretion as whether or not to do that, because it's going to avoid liability at all costs.
Thank you, Gerard. Jessica?
Yeah, so I think to address your broader question about whether this could force or encourage people to move away from our formal financial system, I think that the benefits of decentralized finance, including cryptocurrency, are overblown at the moment. There are not sufficient off-ramps for cryptocurrencies and other forms of decentralized finance to make them viable for operating in a modern economy. That can change, but I'm more of a 30 to 50 years kind of person, not 5 years kind of person. But, and that will happen for some people. I think seeing these emergency measures was a bit of an education for Canadians. I don't think that a lot of Canadians realized that even with judicial authorization, that your account could be frozen or have your assets seized. I think that was new information for a lot of people. And that will certainly undermine some people's trust in the system. Probably people who are already distrustful of the situation, which we should be wary of further pushing people to the margins on that. I think that that's a serious concern. But I definitely agree with Gerard Kennedy on this, that, you know, the measures might have been proportionate, they might have been effective. Those questions are not necessarily for us to determine here, but the problem was really in the application of those measures. And deputizing the banks to make those decisions was probably the biggest problem I saw with them.
Thank you. Michel Comin?
Oui, mais je suis vraiment d'accord avec tout ce que mes collègues viennent de dire. Je pense que l'anonymat, c'est une manière importante de protéger sa vie privée. Et puis, si on pense aux origines du sociofinancement, bien, on passait le chapeau, puis les gens déposaient quelques pièces dans le chapeau. Malheureusement, on est maintenant dans une situation où toutes les transactions laissent des traces. Et je pense que, comme les collègues l'ont très bien dit, il y a vraiment un danger à profiter de ça pour essayer de surveiller toutes ces transactions-là, parce que les gens vont vouloir trouver d'autres façons, justement, de rester dans l'anonymat. Alors, je pense que c'est vraiment... c'est ça, je pense que ce point-là, il est important aussi. Mais je suis aussi d'accord avec tout ce que les autres ont dit. Merci.
Merci, Michel. Christian, do you have a comment?
So, you know, democracy is fragile, and so we need to make sure that we defend democracy. And we've seen the increasing use of emergency powers by democratic governments across the world. And so I think on the one hand, we need to make sure we set disincentives for governments to resort to emergency measures simply because they didn't have the political incentive or motive to update, to ensure that legislation, regulations, our current agencies are properly postured. And then when we do invoke them, we need to build in sort of enough thresholds to make sure that when governments do have to compensate for shortcomings in regular law and in posture in the 21st century, that appropriate, I think, thresholds are forced onto government even under those circumstances. And I think particularly the comments about that the act can only apply very specifically and with more safeguards, I think is critically important, because I think we saw here elements that I think most Canadians, regardless of where they fell with regards to the protesters, were probably not thrilled to see government feeling that it had to resort to extraordinary measures to reestablish the rule of law in this country. And what can we do to avert that? Because if we can avert that, then we don't need to have conversations about worries about trust in the financial system under emergency measures and so forth.
Okay. Thank you very much, Christian. Alors, je pense que c'est tout pour aujourd'hui en ce qui nous concerne. Cette discussion qui a été très riche, beaucoup d'informations. Et j'aimerais remercier nos panélistes, Christian Leuprecht, en ligne de l'Allemagne où il est en ce moment, Michel Galland, Michel Comin, Jessica Davis, Gerard Kennedy. Merci beaucoup à vous toutes et tous d'avoir été avec nous et de nous avoir fait part en fait de vos expériences, vos expertises, vos connaissances. Je pense que c'est, en tout cas, pour moi, ça a été très utile. J'espère que ça l'est aussi pour le commissaire et la commission. Et donc, voilà, merci à vous toutes et tous.
Oui, et j'aimerais ajouter mes remerciements aux panélistes. C'était, pour répondre à ta question, très utile. Un domaine où je dois pédaler très vite et vous m'avez donné un peu un élan. Alors, grand merci et un très grand merci aussi à toi, Patrick Leblond, pour ta contribution et d'avoir bien animé notre discussion. Alors, un grand merci à tous et on va remettre à demain les séances de la commission. À demain à 9h30.
The commission is adjourned. La commission est ajournée.